All rise. All persons having business before the Honorable Associate Judges, down presiding of the District of Columbia Court of Appeals. Draw near and give your attention. God to the United States and the Honorable Court. The Honorable Court has assembled, please be seated and come to order.
Good morning and welcome to the District of Columbia Court of Appeals. Apologies for the bit of the late start this morning. We have two cases on our calendar today. The first is 22 AA 640 Kenner Cisneros Campos versus DC Department of Employment Services. Counsel, when you're ready, if you'll come to the podium, introduce yourself and let us know how much time you'd like for rebuttal.
Morning, Your Honors. May it please the court. Benjamin Douglas, counsel for the claimant petitioner Kenner Cisneros Campos. I would like 5 minutes for rebuttal.
Counsel, if it's easier for you, I believe that the podium goes up here. Some of us need it to go down, some of us need it to go up. So you can go ahead and begin after you get yourself settled.
All right. Good morning, Your Honors. May it please the court. This is a case arising under the special fund regarding an insolvent employer pursuant to DC Code Section 321519. Mr. Cisneros Campos, 11 years ago, had the great misfortune to have his left hand scalded effectively beyond recognition. He still has fingers stuck together, and his employer did not have workers' compensation insurance. And he followed every procedure under the act to secure what he could, getting a default, securing a superior court order, getting those sums from the employer when it remained solvent, but unfortunately it closed down with no known address, no way to trace them down. And so he followed the subsequent procedures to get the sums that were owed to him from the special fund, securing an order from August 14th, 2015 through June 27th, 2019 for temporary total disability. Subsequently, he petitioned the special fund in accordance with the procedures, and after a series of delays and back and forth, they ultimately reached an order which is under review here, effectively saying that the special fund has unfettered discretion to deny requests for ordered sums, even after the procedures carried out, and in contradiction to precedent. They cited a case, Carolyn Hardy, which the CRB had decided a number of years ago, for the opposite conclusion of what the Carolyn Hardy decision said. They questioned whether in fact he was disabled during the time period in which the sums were ordered.
So counsel, is it really your position, and as I read it in the brief, I understood this, but is it really your position that the special fund has no discretion at the point that there's any orders below?
Not at all, Your Honor.
What are
the
the
special
limits
fund
of
has
that discretion?
The special fund has fettered discretion in accordance with the act. It pertains to their financial obligations. The CRB, the director held that in DiVincenzo decision that it's not discretion to go back and retry the facts. It is discretion to consider their financial considerations.
The facts were tried in Vincenzo though, right? In front of the Administrative Hearings Division. That didn't occur here. You had a series of default orders. But it, in the text of the statute itself, it says discretion and after a comma and then goes into the financial piece. Do you view that as limiting what comes before the and the comma, or?
Yes, Your Honor. Justum generis, it pertains to their financial considerations. That's in fact what they said in DiVincenzo. And then when they adopted in McGee, the conclusion that these orders were reviewable, it was all in the context of financial discretion. The director wrote a letter which was appended to the lengthy McGee decision. And that is the consideration. That was also the consideration under the Longshore Act. I've got a citation, the Costello case, 867 F 2nd 722. It's all about financial considerations. And it is not in the discretion to go back and reweigh the facts.
Yeah, the practical consequences of your view. So, I mean, the way it seems to work, if I understand, and correct me if I go off the rails here, is a workers' compensation matter starts and there's a claim is filed, and let's say there's an employer who just like doesn't show up and defaults and doesn't, just or doesn't contest things, perhaps because it knows it has no insurance and has no, is going to declare bankruptcy and has no intent to pay. So there's an informal process where there won't necessarily be required to be proof of disability and like a finding after process. There's just sort of an informal process, issues an order, and if nobody's objecting, it can become final. And if the substantive rule is when that happens, the special fund is on the hook for it without any ability to look behind the conclusions reached in that informal process, you would think that the special fund then would need to protect the fund itself, get involved at the front end of these informal processes to make sure that, in fact, rather than it being, let's say, an unwarranted claim that couldn't be proven, but the employer has no, doesn't show up at all, or, doesn't have an interest in disputing it, perhaps because it really knows it's not going to ever have to pay. You think that the practical consequence would be the special fund would need to protect the fund, be in all these informal cases to make sure that they're warranted rather than unwarranted awards. Is that what you think ought to happen, or do you think it really should just be the case that no matter how little support was created originally for the informal order, the special fund should be on the hook entirely with no ability to look behind it, other than the federal discretion of, well, if we run out of money, then I guess we won't be able to pay anybody else.
Well, Your Honor, I think the current system is completely contradictory with regard to that. So I think it's perfectly fine if claimant goes through the process, special fund categorically does not participate. And there was a lot of language saying that they were.
I have a question, though, follow up to Judge McLeese's scenario. Yes, it's an informal process when you go, you can opt to go through the informal process versus going to an ALJ, right?
Yes, Your Honor.
But it's not just that you show up to the informal process and say, I'd like $117,000 and there's no one here to say that I shouldn't get it, so give me an order. And OWC says, sure, here's your order, right? I mean, OWC reviews the request, no?
Correct, Your Honor. And Mr. Cisneros Campos,
I mean,
I think
if it doesn't review the request and it just sort of rubber stamps any application for $117,000, that's a problem with how OWC is being run, right? I mean, and just to be clear, OWC is just the mayor's agent here, just like the special fund is a mayor's agent. I mean, they're all mayor's agents. So it's just different actors of the mayor looking at different stages of this process. And if they don't like how the process works, then maybe they need to revamp their procedures. But it's not like your client did anything wrong by going and asking for $117,000.
agreed, Your Honor. He was present. He talked about, he had been there before, for one. I could go through the background. The claims examiner knew him. We went through the process. The claims examiner did in fact weigh the evidence.
The claims examiner could have said no.
Correct.
Right.
Correct. She could have said no. That's a portion of its temporary total disability, another portion of its penalties. And I also say that the special fund has discretion to say, considering our finances, maybe the penalties, that's against Long Brothers Cleaners. That's their problem. We didn't do anything in bad faith, but the temporary total disability is out. So there's discretion there. So I wanted to note that it's 43,000.
I'm going to cut you off, though, because I do want to talk to you, as sympathetic as we may be to your merits arguments, there's a jurisdictional question. And I'd like to get to that first, because I think that is an important question that we need to grapple with. So you're appealing from an order from the special fund denying your client funds. And in order for it to get to us under the APA, it has to be, this has to be a contested case. And the government is arguing that this is not a contested case because there was no trial type hearing, or it's not that there was or wasn't a trial type hearing in your client's case, but that your client is not entitled to a trial type hearing under a statute or a regulation or the rules of due process under the Constitution. And so I'd like to hear what your response is to that.
Yes, Your Honor. So the APA does not exclusively say contested cases. There's also a legal interpretive for declaratory judgments. And under section 321522 of the Workers' Compensation Act, the compensation, excuse me, 1522B3, the Compensation Review Board interprets the act, and this court reviews those legal interpretations. I think the best precedent to highlight this, or the two precedents, are Renard and the Clark Construction case, Chavis, 123 A3rd 199. In Renard,
I'm sorry, can we just break down what you're saying? Because I want to make sure I'm understanding. So I go to 13-1522 B3. And 1522 is about review of compensation orders. So first, I think the first hurdle is that we have to assume that the special fund order denying your client's funds is a compensation order. And I'm not, it's not totally clear to me that it is. I mean, if you look at 1519, it's not clear to me that it is, but we can get back to that. But let's assume that it is a compensation order. B3 says pursuant to the DCAPA, any party in interest who's adversely affected or aggrieved by a final decision rendered after review of a compensation order can come to this court. And so I'm trying to understand why you think pursuant to the APA, that would seem to incorporate the contested case requirement, which I'm trying to figure out where it is you think there are statutory or regulatory requirements that obligate the special fund to have a trial type hearing.
Your Honor, the petition is not for review of the specific decision of the special fund, but for the legality of the CRB's interpretation of the act. And I think the Renard case and the Chavis case, in Renard, this court held that when claimant requests a change of treating, or when claimant requests a change of treating doctor, no formal process, informal OWC, not the Administrative Hearings Division decides. That's not reviewable, not a contested case. Given that precedent, and in fact, citing that precedent at one point in Clark Construction, this court nevertheless found that the CRB's interpretation of the change of treating physician section in relation to whether an employer can request a change of treating physician, that interpretation is subject to review. And I believe the clearest reconciliation with the Administrative Procedure Act is the declaratory judgment. It's not exactly a declaratory judgment, but it is an interpretation of law and not a conclusion that was under review. There will be no factual deference, no question of substantial evidence or anything like that, but rather the CRB's interpretation of the act saying that employer can't request a change of treating physician. That is something that is reviewable on this court under 1522B3. And in the same way, their review of the special funds review that says we can go back and second guess a final order issued by OWC and then by Superior Court. And we can change our mind from our precedents without explaining ourselves, Hardy and DiVincenzo, and the fettered discretion of the special fund is somehow without fetter, which is essentially what the holding is. All of those legal conclusions, all those legal interpretations of the act are reviewable. And if we adopt the view that nothing under this heading can be reviewable by this court, it has the curious effect of freezing every interpretation of the Workers' Compensation Act up until now.
Well, no, right. I mean, all it means is if it's not a contested case, it can't come to us directly under the APA. And what it means is that your client has to go to Superior Court or could go to Superior Court to seek review or to bring a suit against the special fund to say you've acted in an arbitrary and capricious way, and the Superior Court would rule on that, and then it would come to us from Superior Court because we have general jurisdiction to hear cases and decisions by the Superior Court. So it doesn't cut off the development of the law or review of the special fund's decision making. It just sends it on a different path because we are bound by the contested case rule of the DCAPA. So you're citing to Renard the same case. So the problem, part of the issue or difficulty for me following along with your cases is that you didn't file a reply brief. Is that correct? And so you're citing to the Renard case that's cited in the government's brief. Is that correct? The 731, second, 413.
Yes, Your Honor.
Okay.
And that was cited in Clark.
And then, okay.
And in none of these cases did either the government or or an uninsured employer or a claimant go through Superior Court. The cases cited by respondent include statutory bases for going to Superior Court as well. I understand it's a court of general jurisdiction, but in Burkhart, in another case, Nunnally, that they cited, 88 3rd 1004, it said that the Superior Court as a venue can be rebutted by clear and convincing evidence of the contrary legislative intent. I think 1522b3 is such, and I think that is the best way to reconcile this court's repeatedly hearing questions of legality, not specific conclusions by OWC, not specific conclusions about whether the claims examiner did things right, but the interpretation of the law by the CRB in cases that one might label as non-contested are nevertheless reviewable in this court.
So if I understand your argument, any decision by, I mean, it wouldn't be, as far as I could tell, specific to the workers' comp setting, any agency decision that decides a question of law, in your view, is reviewable directly in this court without regard to whatever the process is, if the issue that is being presented is a question of law. Is that the theory you're presenting?
No, Your Honor, under the Workers' Compensation Act.
Why,
What limits that?
What
What
limits it, Your
creates
Honor?
those limitations that it's just under the Workers' Compensation Act?
I believe it would have to go case by case. In the administrative procedures outlined in Nunnally and Burkhart, there was a review of Superior Court. If it's silent, then it goes to Superior Court. If it says Superior Court, then it goes to Superior Court. When it specifically says that there's an administrative body reviewable by the Court of Appeals, I think the Court of Appeals is appropriate. So I think that is a limiting principle. I'm sure it applies to other acts of which I'm unaware, but in the Workers' Compensation Act, there is a specific provision, and it says here, it doesn't say Superior Court.
I mean, it's my recollection and belief that we have a lot of cases where the issue being presented to us was legal in character, and the suggestion was that it was a contested case, and we, instead of saying, well, this is a legal question, so we can review it, at least unless some other statute precludes us from doing it, we can review it directly and immediately. We instead kind of apply the contested case requirements, which focus on whether under the relevant procedures, there was the right kind of an entitlement to trial type procedures if there were disputed facts that needed to be resolved.
I'm aware of such cases, Your Honor. I don't think they're disputed facts here, really. I think that
For sure. And I mean, it's a little tricky about what a contested case is relative to that. I mean, clearly, in some sense, you have no absolute right to a trial type proceeding, even if you file a lawsuit in Superior Court. If your claim doesn't, it completely fails to state, if your complaint fails to state a claim, then you can be subject to dismissal. There'd be no contested facts and there wasn't a trial type proceeding. And the same can be true in agencies, but those are still contested cases. They're treated as contested cases if, assuming there is a disputed fact, so the availability under agency procedures of the possibility of dismissal or the equivalent of summary judgment doesn't mean that a category of cases is not a contested case. The way we've interpreted that, as I understand it at least, is that if you have a right to trial type procedures, if there is a disputed fact that needs to be resolved, then it's a contested case. So I don't know that it really turns on whether there ended up being either an absolute right in every case, even if there's no factual dispute to trial type hearings, or whether there was a trial type proceeding in your particular case. Those aren't quite the test. It's a little trickier than that. You agree with that, or you disagree with that?
I don't disagree, Your Honor. What I'm saying, I think, is that this court's precedents are best reconciled with one another by viewing 1522b3 as a mandate for review of specifically of the legality of the legal interpretations of the CRB's decisions, and that this is specific legislative intent that it doesn't go to Superior Court.
And just to be very, very clear, that is an argument that even if this is not a contested case within the meaning of the DCAPA, 32-1522 creates a separate road to get immediately to this court.
Correct, Your Honor.
And are you arguing that this is a contested case within the meaning of the APA, or are you relying entirely on the 1522B path to this court?
I am Neither, Your Honor. I'm relying on 1522 and the APA's allowance for some exceptions, including legal interpretations and declaratory judgments. I'm not claiming it's a contested case,
You're not, got it.
but I do think the APA allows it, and I think that's reconcilable with 1522.
And to the extent you rely on Clark or Chavis or Clark Construction as support for that, do you agree that although there's a reference to Renard in Clark Construction, it's not about a jurisdictional question, and nothing in our opinion in Clark Construction discusses the question of whether that was a case that was appropriately brought directly to this court?
Your Honor, I believe that wasn't contested there, but as I stated earlier, what happens to that precedent becomes a peculiar thing if a subsequent decision to the contrary by the CRB is not reviewable by this court. So even if the jurisdiction question was not discussed.
And why does it, this is back to Judge Easter's question, but why is it a peculiar thing if the issue is only, I mean, you can definitely get the issue to this court. The issue is whether it comes directly here or whether you have to go to Superior Court first and come here if you're dissatisfied with what the Superior Court has done. Either way, there is review in this court, so it doesn't really affect, I mean, it has consequences, practical in character, but it doesn't interfere with the development of the law or the opportunity to get your arguments in front of this court. It's just a question of how winding the road is or not winding.
Your Honor, I think that this detour through Superior Court does impact, we might call the conversation and interpretation of the act between this court and the CRB that 1522 mandates. We've jumped through a lot of hoops in this case, and so if we have to jump through some more, so be it. But I think that that's a peculiar, given the CRB's specialized knowledge and given this court's experience reviewing the decisions of the CRB, none of which have been dismissed in a legal review, to my knowledge, thus far on the contested case requirement. I think that direct appeal to this court makes much more sense. I think that it's a peculiar circumstance if this court said in Renard, we're not going to review whether changing from Dr. Jones to Dr. Smith is proper on a contested case basis. Like, that's fine. And then later say, but wait a second, we can review, the employer can't decide which doctor's better. The employer can't raise that issue. That's a legality question, direct review from the CRB.
Well,
there were
we
remands.
didn't say that. We did it, but we didn't say it.
Okay.
And unless I missed something that you think is in Clark Construction.
No, Your Honor. I believe that the actor review is an implicit interpretation of reviewability. All I'm noting is it's a peculiar result if this court held that in Chavis and sent it back to the CRB. The CRB said, go fly a kite, and did the opposite. And then that couldn't come back here because it's not a contested case. I'm not saying they would do that, of course, but if they did, that would seem reviewable under the mandate of the Workers' Compensation Act to have this court review the judgments of the Compensation Review Board. So.
All right, counsel, we're going to let you sit down and hear from the government, and we'll let you have some time for rebuttal.
Thank you.
Good morning, Your Honors, and may it please the court. My name is Dia Roshinario, and I'm here on behalf of the District of Columbia Department of Employment Services. This court lacks jurisdiction to hear this case. As this court is well aware, it can directly review agency decisions only in contested cases. So those are cases where a statute, regulation, or the Constitution entitles the petitioner to a trial type hearing. And petitioner concedes here that the statute, regulation, and doesn't make any claims about the due process clause, entitles him to a trial type hearing. And that, Your Honors, is dispositive.
A bit of an overstatement to say that we review agency decisions directly only if it's a contested case. I thought there were some statutory, some other special statutory provisions that authorize that, and then some confusing cases about the extent to which the Home Rule Act permits or does not permit that.
So you're right, sorry, Your Honor. There are specific circumstances where Congress has also given this court jurisdiction, I believe, to review other types of cases. And then there are cases that say that the DC Council can move some of the contested case jurisdiction to the Superior Court first. So where the Superior Court can first consider cases even though they are contested cases. But there are not cases that expand the jurisdiction of this court beyond the contested case requirement outside of, yes, the statutes that Congress enacted that specifically give review of those types of cases. And this court has specifically held that the DC Council cannot expand the jurisdiction of this court. So for example, so even if an order by the special fund awarding or denying payment is a compensation order, which I don't think that the court needs to address in this case, the DC Council would not be able to use that in order to expand this court's jurisdiction. And I believe both Burkhart and Renard, discuss that limitation on the DC Council's power.
Expanding this court's jurisdiction, I mean, it's sort of an interesting way of phrasing it, because certainly you agree that we have the authority to hear cases where due process requires a trial type hearing, right? Regardless of what a statute or a regulation says, if we think that there's a due process interest at stake, right?
Yes, yes.
And I found myself wondering, I mean, this case has had quite a life, right? Where Mr. Cisneros Campos is indisputably seriously injured and tries to get compensation from his employer. His employer goes out of business and can't be recovered from. And Ms. Cisneros Campos still needs medical care, is still apparently out of work, and goes to OWC, who's just a mayor's agent, just like the special fund, right? And OWC says, I'm awarding you $117,000, right? And then Mr. Cisneros Campos takes that to a superior court and gets a judgment for $117,000. And then he takes it to the special fund, and the special fund says, actually, we don't think you're entitled to temporary total disability benefits. We're paying you zero amount of dollars, even though I think there's really no factual question that Mr. Cisneros Campos is disabled in some respect. So he's got a superior court judgment. He's got an order from OWC, who's, like I said, just a mayor's agent, just like the special fund administrator is. Doesn't he have some sort of, put aside that the special fund wasn't in the room? I mean, again, they're just all mayor's agents, right? The OWC was there. Doesn't he have some sort of due process interest in the $117,000 that he was awarded and then got a superior court judgment to under 1519A?
So the judgment that he has is against the employer.
I get that, but he has a property interest in that, right?
Yes, he does, Your Honor.
Right. Okay. And then the question is, he's trying to go under 1519B to the special fund to say, here, I've got this judgment for $117,000. You all told me I could get this judgment. I couldn't get the judgment without going to you first, you mayor's agent people. So I did that and I got a court judgment. And now I would like to be paid from the special fund, which is here to pay people like me whose employers have gone out of business. He doesn't get process for that. I mean, they can just say, yeah, never mind. We know you went through this informal process, which we invite you to do because, we don't want our ALJs to be overrun. So we give this other easy process for people to go through. You don't think he's entitled to some due process type process, a trial type hearing to say, well, actually, never mind. We don't think that you're entitled. We made a mistake. So we'll give you a hearing now to see sort of how much money you are entitled to.
So I think there are two separate questions here. So one is he entitled to a trial type hearing? And then the other,
that's what I'm getting at, right? Because we agree he's got a property interest in the $117,000 judgment.
Yeah, so the statute does not mandate payment from the special fund. So to be clear,
I get that
right,
too.
but so the Workers' Compensation Act says that if you have a default judgment and you can't collect on it, there is a special fund. And it authorizes the mayor to make payment in her discretion and to the extent that she determines advice.
Right, but if the mayor is not going to say, this isn't a case where the mayor said, look, the fund is low and all we can do is pay you 50 cents on the dollar, right? This is a case where the mayor said, actually, we don't think that you're entitled to the $117,000. The $117,000 that we, being mayor's agent people that we are, already said that you were entitled to. So essentially, they're conducting some sort of override. And I'm wondering, is there some argument to say, actually, at that point, if they're going to override their other mayor's agent colleagues, doesn't he have some due process type, trial type hearing rights for them to override it? I mean, they can ultimately decide, hey, actually, we think that you are only partially disabled. Hey, we think that, this is what you could have earned, right? They can get into all of that, but shouldn't they give him a trial type hearing at this point if he's gone through all of these other hoops and gotten $117,000 judgment that he couldn't have gotten if he didn't get the supplementary order that he was required to get under 1519A?
So there's only a due process interest if there are a specific set of criteria that mandate a particular outcome. And-
Just to be clear, that suggests that there's I think Mr. Cisneros Campos's attorney has sort of disavowed this line of argument because it's an argument this is a contested case. But leaving that aside, it seems as though the gist of this discussion means that there is potentially a relationship between the merits and the contested case issue. Because your answers about why there's no due process interest in recovering from the fund, whatever, there may be a property interest against a private entity, but to the extent you have a property interest assertable against the government, it turns on, can you recover from the fund? And so your answers are, well, you have no right to recover from the fund, which is the merits argument.
There is a
And so
little, yeah.
imagine the statute here said, anybody who has gotten a judgment from Superior Court arising out of OWC proceedings has a right to be paid that amount. If the employer can't pay it, the special fund will pay it unless the special fund lacks funds. So imagine the statute said that explicitly. Would you agree that there would be a constitutionally protected property interest assertable that would give rise to an entitlement constitutionally, whatever the regs or statute said, to trial type procedures if there were contested facts relating to that topic?
Well, that would definitely be a very different case because it would mandate
Obviously,
in a certain set of
I'm
circumstances,
interested in your
a
answer.
particular outcome.
Right.
Well, the case that comes to mind the most is the Washington Legal Clinic for the Homeless case in the DC Circuit. So that's one where the DC Council provided certain objective eligibility criteria for families for emergency shelter. And said, if you meet these criteria, you're eligible to get shelter. But there was not sufficient funding, and it provided discretion to the city administrators to determine how to allocate those funds. And the DC Circuit held that there was no property interest here. There's no legal entitlement because even if you met all of the eligibility criteria, you would still not be entitled to emergency shelter. And that would be this, I would think that would be the same case here. It kind of depends on, I guess, how constrained the financial portion of it is. But, even if you had a statute that said, the mayor must make payment, if there is still discretion to allocate funds, for example, perhaps the mayor might determine that certain types of disability claims should have priority over other types.
Can I, back on jurisdiction, assume that we agree with you that direct review is not available in this court. I just want to make sure I understand what the practical consequences of that would be. And I guess the starting point for that is, I believe, although I don't know that the parties focus on this, that the CRB told Mr. Cisneros Campos to come to this court.
Yes, Your Honor, and that has happened in other cases where the court has determined that there is no contested offender jurisdiction.
But I guess my question is, do you agree that in virtue of that direction to Mr. Cisneros Campos, that if Mr. Cisneros Campos, if we were to conclude that Mr. Cisneros Campos incorrectly followed that advice and came here and instead is required to go to Superior Court, do you agree that he would be entitled to do so without any kind of bar with respect to the timing of his doing so?
Yes, Your Honor. Yes, I think we would be stopped, especially since the order says that he can appeal to this court. And, you know, yeah, those kinds of considerations, so like orders directing parties to this court have happened before. If it did go to the Superior Court, I mean, then the Superior Court could determine any questions, unless the due process requires an actual trial type hearing. Any other questions about what process is due would be something that would need to be determined by the Superior Court. Oh, and I guess the other case that I would want to draw the court's attention to for, I guess, the question of objective criteria is the Rones case, which involved the home purchase assistance program and a loan from the home purchase assistance program. And there the court didn't ultimately reach the question of whether there was a property interest or not. The court ultimately held that, well, even if there is a property interest, this is not the type of case where that property interest would require a full trial type hearing with a full panoply of procedural rights. But in discussing the property interest, it was incredibly skeptical of whether there was a property interest at all, even though there were objective criteria for whether someone was eligible for an HPAP loan. And that was because you weren't guaranteed to obtain that loan just because you met the eligible criteria.
But I'm assuming there wasn't a Superior Court judgment. There was no trial court judgment saying you get the loan.
But there is no such judgment here that obligates the special fund.
That obligates the special fund, but only because the OWC already said in a supplemental order, you're entitled to $117,000. The OWC, who's just a mayor's agent, just like the special fund folks are.
I think it would make sense to take a step back and look at the OWC procedures in general. So informal proceedings are not adjudicative findings of fact proceedings the way that a trial is.
I understand all of that. That seems to lead us down a road to telling people don't use these procedures, right? Which I don't think is what the district really wants. I think the district wants to have two paths available. And I also don't think as a statutory matter, it really matters, because at the end of the day, whether you go to an ALJ and get an order awarding you funds, or whether you go through the informal processes, in order to get to the special fund, you still have to go through 1519A and get the supplementary order. Right?
So you get a supplementary order of default. That's also
either way, whether you go through the formal process or the informal process, you have to get that supplementary order from OWC.
Yes, that's right, Joanne.
Right. So it doesn't matter what process happens before, right? You have OWC blessing it either way, saying, yes, you're entitled to this money. And I don't understand why the district would want to say, well, actually, you only are entitled to the money if you followed the more trial type hearing process preceding the supplemental order. Like, that doesn't make any sense to me at all. And I guess that's one of my questions is did you really mean that in your brief by saying, well, this might be a contested case if he had gone to an ALJ first, then gotten the supplemental order, then gotten a Superior Court judgment, then gotten to the special fund and been denied, then you could hear this case.
So, Your Honor, that would not make this a contested case, because the actual decision before the special fund is still not a decision to which he is entitled to a trial type hearing.
Right. So why are we talking about which process he went through? If that's your argument.
So the argument about the process that he went to is only on the merits. So only if the court determines that it has jurisdiction.
Okay.
And I want to be clear. I want to be clear that we're not arguing here that Mr. Cisneros Campos did something wrong by going through the informal process. The only question is whether that informal determination binds the special fund, or whether it has discretion to look at the underlying facts and say, is there evidence for a claim of temporary total disability here that would support this finding? And that question, that look at the underlying facts, is part of the custodian of the special fund's obligation to ensure that the funds.
Do you think that the special fund also has an obligation to just figure out, regardless, okay, so he had the misfortune to choose the less onerous path, and he went through the informal process. And so no one ever questioned that he was entitled to total temporary disability benefits because his hand is not functional, right? It got 4th degree burns, the most serious kind of burns you can get, and it is not functional, and his fingers are fused together, and no one ever questioned it, right? Do you think that the special fund has an obligation to say, okay, we don't think because of the informality of this process that he's entitled to those types of benefits, but he's entitled to something, right? Like, why isn't it arbitrary and capricious for the special fund to say, sorry, you don't get $117,000. Actually, you get zero.
So the special fund did find him entitled to medical care. I do want to be clear.
Right,
with that.
but they said you get zero in the form of unemployment benefits.
Because the special fund only has ability to pay defaulted judgments that have gotten through the Superior Court. So once there is a default order,
But he had that. But then the special fund said, sorry, we're not paying. Because we decide, we other mayor's agent people are going to second guess the first mayor's agent people and say, you don't have a temporary total disability. But clearly he's got some disability. I mean, the special fund itself is saying, yeah, you have a right to payment for reconstructive surgery to separate the fingers that are fused together. So he gets zero for disability benefits, for unemployment benefits.
he hasn't requested partial disability or other like a schedule.
I mean, clearly he's asking for some sort of unemployment compensation, right? And the special fund goes from 117,000 to nothing.
So the
That
special-
seems arbitrary and capricious to me.
The special fund is limited to awarding the types of workers' compensation judgments that were actually ordered by the Superior Court. And so it cannot look behind that and award a different type of judgment. Again, this isn't about him making a wrong choice. This isn't about him not having an opportunity to show that he is. This would be a very different case if he had put in medical evidence that said he cannot work. He's completely and
Does the
totally
special
disabled.
fund have no ability to seek that out?
It does have an ability to seek that, and that's what it did in this case.
It's got the ability to do investigation, right?
Yes, Your Honor, and that's what it did here. It requested medical evidence. And this is why when the CRB first determined that the custodian of the special fund has the discretion in the informal, if there had been an informal proceeding, to look at the underlying merits of the disability claim, it remanded it to the special fund in order to give Mr. Cisneros Campos an additional opportunity.
Right, and Mr. Cisneros was given 30 days to put forward documentation and he asked for more time and he was denied.
So he asked for more time. He was granted more time. He had another 60 days in order to do that. He asked for more time again. And at that point, it was denied because he had said that, oh, I think I could get the documents in. He submitted the document from Mr. Pablo. And then I believe 2 weeks later said, hey, I've submitted my documents. It's been 15 days. I want a special fund decision. And he has never brought up before the CRB that he didn't have an opportunity to fully submit medical documentation or submit affidavits or any sort of other additional evidence to show that he was temporarily and totally disabled. His sole argument is that the special fund can't investigate this type of claim at all. And again, we're not saying that he made some sort of mistake or anything like that by going through the informal procedure. What we're saying is that when you go through that kind of an informal procedure where the claims examiner is not a lawyer, where you can't have witnesses, no one is under oath, he didn't introduce any documents. The memorandum of informal conference from the 2018 procedure shows that he didn't attend. So there haven't been any documents submitted in that prior procedure. We're just saying that it is not an abuse of discretion for the special fund to say, when I'm deciding how to allocate these funds, I want to make sure that they go to people that have a substantial
There are
issue.
medical records before the special fund that say that his hand is fused together and is not operable.
So two of his
So,
fingers are
anyway.
fused together, and then his own medical expert says that he has a partial impairment of 45% of his left hand,
45%, yeah.
which is not a temporary.
Counsel, seeing that there's open questions there, should the fund do something? Or is it your argument that they're not capable of doing something like kicking it to the Administrative Hearings Division and saying, okay, you went through this informal process, we can do our investigation, but we don't have the full capability to resolve some of these questions. Will you go do it, or is the person just out of luck in your view, based on their decision to go in the informal process to start with?
Also, the person can always go to the formal process again later, like, so after you finish the informal process, you have an opportunity to reject the recommendation.
No, but in this case,
In
for
this
example, assume, and this is to follow up a little bit on an answer you gave about what the options of the special fund were in this case. So assume that the information comes into the special fund that maybe, at least at the time this is now being litigated, there is not medical support yet identified for total disability, even temporary in character. I thought you said the special fund is limited only to providing the type of disability that was in the award. And it just isn't obvious to me why that's so. It says that the special, so someone comes with an award and it says total disability, and the special fund looks at it and says, well, that was through informal proceedings. Doesn't really seem like it's fully warranted, at least now. Maybe it was, who knows? But we have discretion and we can, pay people what we want. And there's, the statutory language in your view is very unfettered. And why couldn't the assistant director say, we're not going to pay all of it because that was through informal process and doesn't seem to support it. But in my discretion, I'm going to pay, benefits that reflect the uncontested medical information that we have been provided, which would be less than, but something relative to what was created by the Superior Court orders and the informal process. Why do you say that
I do
there
think-
is that limitation?
Yeah, I do think that the director can say, we'll only pay a portion of the benefits. So for example, here, there are the disability benefits and the penalties. The director could say, we won't pay the penalties, but we'll pay the disability benefits. But here we're discussing moving to a completely different type of temporary of disability benefits, and from either a total disability to a partial disability, or moving to some sort of schedule
Right,
award.
but why don't they have the discretion? And is your answer, oh, the special fund isn't really expert in that? Is that the cause of your concern? Because if that's the cause of your concern,
No.
then I don't really understand why the special fund should be second guessing what the OWC said.
My cause for concern is just the statutory language, Your Honor. So DC Code 321519B begins with, in cases where judgment cannot be satisfied by reason of the employer's insolvency or other circumstances precluding payment. And so it specifically mentions judgment, and then the preceding paragraph is about the judgment from the Superior Court.
It says
it's-
the mayor in his discretion and to the extent that he shall determine advisable. Right?
Right, but it does say in cases where the judgment cannot be satisfied. And so that would be. my
That's a
cause for concern.
predicate circumstance. And this is a case where the judgment can't be satisfied because the employer doesn't exist anymore. There are no funds to be
Right.
had.
And then it says
But
make
then
payment
the
from.
mayor has total discretion to the extent that he shall determine advisable.
So then it says
Right.
make payment from such fund upon any award made under this chapter. And so there's an award that's made under this chapter would be the award for temporary total disability benefits. There's no award here for partial benefits or for a schedule award or
So
anything like that.
If imagine that somebody has gone through the entire process and has gotten a 50% permanent partial disability scheduled award. And but it was through informal processes, and then the matter comes before the special fund, and the special fund looks into it and actually says, well, that was very informal. We'd like to have some medical documentation before we actually expend public funds to they're scarce in character to provide support for this, to recognize this award. And the information comes out that it really seems like it might be 40%. You would say the special fund is stuck with either fully honor that award or honor it zero. Or is that upon the award, but not fully compensating for the award because there's doubt about the proper magnitude of the award?
Yeah, I think it's moving very far away from this case, and I'm
no,
unfortunately, I'm just like not familiar with
The
it.
reason it's relevant, I mean, again, assuming either it could be relevant down the road in Superior Court if that's the road that, that's the twist the case has to take, or it could be relevant here to whether there's an abuse of discretion. If you assume that the special fund had discretion to not just either say zero or complete honoring the award, then the question might be, and there's a question whether that's been teed up here too, but a question might be, well, how reasonable is it to completely zero it out if it seems like uncontested medical information suggests that there is a compensable disability, if not in the magnitude, and or perhaps also not in the same exact legal category of disability as the award that was obtained through informal proceedings. And that's seems to me it's potentially relevant in the future of this case if the case has a future in Superior Court. And it might be relevant here, I guess, depending on what arguments you think your
I
opponent
think it
is
might be
making.
relevant in a case where the petitioner had raised that argument, before the special fund or the CRB. He didn't here, and so I don't think it would be an abuse of discretion for the special fund not to consider alternatives that he did not himself raise.
But I perhaps, but Partly I was just interested because the statement was made at argument by you that the special agent had the special fund had no ability to award different types of compensation that were the predicate for the order. And that just seems to me not at all clear. I'm not sure it's wrong at all. It seems to me quite unclear.
Yeah, I don't think that there is any like DC Court of Appeals
Or is
decision
it
or anything,
PRB?
or anything like that, or it's exactly.
You know, if there's any administrative support for that line of thought in the decisions of the CRB or published determinations of the special fund?
I mean, Hardy is the one where the petitioner had gotten a Superior Court default judgment, but hadn't gone through the procedures of getting the supplementary order first. And so the CRB affirmed the denial of special fund benefits, saying you didn't meet the statutory prerequisites for that. So it seemed to at least suggest that there needs to be you have to follow all of the steps. You get the supplementary award based on the award that was, actually awarded to you. You get the default order, and only then can the special fund look at it. And now this is in the cases of payments for award. It's different with respect to medical treatment, because that's like further on in the statute where it says that may or may can provide any necessary medical treatment in her discretion. And the way that functions is that as the special fund did here, once the special fund awards medical treatment that arises from the injury, then it would deal directly with the doctors who would submit their request for payments to the special fund.
Well, counsel, I don't know that it's for us to fill, but would you agree that there at least appears to be some sort of process gap somewhere in here? Once it gets to this advanced stage where there needs to be some sort of opportunity, I won't say it that charge. There just appears to be a gap somewhere that someone's going to have to fill in.
I don't agree, Your Honor, and that's because I don't think that there's a protected property interest here. And this is because, even if we didn't have, even if the special fund said absolutely, we completely 100% agree, you are temporarily and totally disabled, that wouldn't mandate that he receive payment from the special fund. Because again, this isn't an unlimited resource, and the custodian needs to allocate payments between different people. And so, for example, perhaps the special fund can say certain types of disabilities will cover certain types of disabilities, but not others. If that is a
But it needs to
reasoned
be able to do
judgment.
that on a reasoned judgment. It needs to be able to do that on a reasonable basis. And part of the problem that they're exclaiming here is that this went through an informal process, so that's not there. But I want to take you briefly in another direction. You haven't really addressed this yet, but let me start with a kind of predicate question. Do you agree with that en banc CRB decision in this matter?
We agree with it to the extent that it talks about the special fund's discretion to review the underlying order, and we don't question the CRB's jurisdiction in this case to review special fund decisions.
So one of the things your opposing counsel was raising was that if the CRB is making legal determinations aside from necessarily the contested case requirement, that should come to us here at the Court of Appeals. I found that to be a quite interesting argument, because as I thought over my administrative experience, it seemed to me that I was having trouble recalling any time where we have an intermediate reviewing body of an administrative nature, and we don't tend to take the appeals directly. We even have some agencies where there's kind of a combination. For instance, the Office of Human Rights making probable cause determinations, those go directly to the Superior Court. But if it goes all the way through the Commission on Human Rights and a tribunal of commissioners makes a decision, then that comes over here to us. But the same type of procedure, if it goes back, if it's a DC government case and goes to the Director of the Office of Human Rights instead of the Commission for final decision, even though an ALJ worked on it, that goes over to Superior Court too. Why doesn't it, what do we expect the Superior Court to add beyond the CRB's expertise that we need to go through them to come to us if the CRB is reviewing?
So Renard did involve a similar type of case. That was one where there was a statutory section of the Workers' Compensation Act that provided that the mayor had discretion about whether to change the physician. And that went to, at the time it was the director, not the CRB. So that went to the director, and then it came to this court. And the fact that it had gone through some sort of intermediate review did not change anything. And at the end of the day, the contested case question is whether there's a right to a trial type hearing with a full panoply of procedural rights. And that doesn't exist before the CRB. The CRB is strictly reviewing the decision from the special fund. It's not engaging in a full trial type hearing. And so once you don't have a right to a trial type hearing, there's no contested case. And so even if it might seem a little bit duplicative. I think that's true in a lot of these cases, where the Superior Court will do an arbitrary and capricious review, and then this court will do a de novo arbitrary and capricious review as well. But if there is no contested case jurisdiction, again, the DC Council cannot expand that, and neither can this court for like policy
So
reasons.
if Mr. Cisneros Campos did have to go to Superior Court, he could get that child type hearing in Superior Court and put on evidence that he is entitled to funds from the special fund.
I think that would need to be decided by the Superior Court. Ordinarily, you would do an administrative deferential review in Superior Court. It would be a very, very rare case where you would do a de novo trial type hearing. And again, what would, because this is like within
Which leads me back to Judge Howard's question of what does that add, right? Isn't the point of going to Superior Court to give the litigant access to the trial type procedures that they didn't get in the agency matter?
and this is just about whether there was a trial type hearing at all in the agency matter. And if there wasn't, there just simply isn't jurisdiction here. And whether, there's wisdom to that, I don't know, but the court has repeatedly held that if there is no right to a trial type hearing, then it is not a contested case.
Is it your view that this gets back to I guess the scope? It's partly about jurisdiction, partly about the merits because they sometimes intertwine. But from your perspective, do you think that the special fund could say, here's how we're going to exercise our discretion about paying defaulted awards for employers who can't pay? If they were established through full procedures and an ALJ making findings, then we will honor them subject to the ability of the fund to bear the expense of it. But if they were informal, we won't recognize them. We will not pay them. And that's just, that would then mean if you're a claimant and you're concerned that your employer might not be able to pay the award, then you probably would have to go through formal proceedings if you wanted to keep that option open. But do you think
Sure.
that would be a lawful exercise of the discretion that you understand the statute to confer upon the special fund that's been delegated by the mayor to the, I guess, the assistant director of OWC?
I'm just not sure if the special fund is authorized to make regulations in and of itself. I do think that DOES could make regulations that constrain the special fund's discretion perhaps a little bit more than the statute would. And
Well,
say,
I was more
here's the
thinking that the
guidelines.
special fund would, the assistant director would issue a written statement saying, I'm denying it because I just don't recognize, I choose not to recognize these, and our funds are limited, and we're gonna confer them on folks who are not, you're not unfortunately in, which is people who got their awards established in formal proceedings and therefore are reliable.
I think that'd be a harder question, and you'd have to decide whether that is a reasoned basis for kind of categorically denying all claims. And that's not what the special fund did here. They didn't say you went through an informal process, so out of luck, nothing you can do. They said you went through an informal process, and so we're not bound by that. We're not precluded from investigating this further and seeing if there's any evidence supporting your claim. And, you have full opportunity to submit the additional evidence before us, and
And then
we
you
can
think
make a
that's,
decision.
so if that's what the assistant director says after an investigation, what is the nature of the CRB's review of that? Is it treated as a question of fact, or is it, do you view the special fund as the assistant director as having found facts through pretty truncated procedures, or what's the concept of what the CRB is doing when reviewing a determination that rests on kind of, it's true there's an order here, but it was on informal proceedings. We're not bound by it. So we're going to make our own conclusion about whether we're going to award it or not, that turns in part on our factual concerns about whether you're entitled to the award that you got.
It would be an abuse of discretion standard. So the same way that it would be in any type of case where there isn't a formal hearing, you look at the reasoning of the decision and whether there was a reasoned basis for it. And then, of course, if the facts are completely wrong, right? Like if it's completely unfettered or divorced from the facts in the record, then that would be an abuse of discretion, and the CRB could overturn it for that reason.
And I assume, do you think the CRB could overturn that result on the theory that the process that led up to it was unfair? Meaning, imagine that there's an order that arose out of informal proceedings, and an application, and all the process has gone through, an application is made to the special fund, and the special fund says, we're not really sure. The claimant says, well, I'd like to prove it up. I want to testify. I want to submit a deposition. I want to call my doctors. And the um, uh, special fund through the deputy or the assistant director says, we have limited time and ability, and we're not really interested in looking behind all that. We, your proffer isn't that great, and we're just going to say, sorry, we're not interested.
I think the CRB could determine whether it abuses discretion and
The
limiting.
process was, it was so unfair as to be an abuse of discretion.
Yes, that would be an abuse of discretion if the process is so unfair that there's no. If there are no further questions, we ask this court to dismiss this petition for review. Thank you.
Thank you, counsel. Mr. Douglas, we'll give you just a few minutes.
Thank you, Your Honors. What I meant to say earlier, this court does not need to address, I don't think, the contested question case for the reasons that I outlined earlier. But I actually think the Washington Legal Clinic for the Homeless case supports the position that claimant has a proprietary interest in this. The majority in dissent in that case are most credibly read as having a debate about the extent to which the discretion allowed is fettered or not. And the majority says if there's unfettered discretion, clearly there's no constitutional right. But if they're bound by X, Y, and Z, then clearly there is. And they don't really talk about fettered discretion. And the dissent says, no, this discretion's fettered. And therefore, there is in fact a right, even if they can't guarantee housing to or emergency shelter to everyone. So I think that was more a factual question about the discretion there. In this case, I was focused on the fact that the CRB has repeatedly said that there is fettered discretion and that their judgment in this case was completely contrary to that. And the inconsistency between the holding in this case and all of the prior holdings, and even one subsequent holding actually in the Dennis case, CRB number 23-001, where they talk about the special funds use of discretion in relation to its funds, which is what the statute outlines. So there is a due process right on there. I'm not conceding that point. I'm simply saying that the court does not need to address the contested question issue. Just to note that the CRB's interpretation is completely contrary to its own precedents and to the act.
Let me ask you a question, counsel. At the point that your client was coming back and pursuing the default order in the informal process, your client was already aware that the company, the cleaner, was bankrupt, insolvent, or about to be, right?
Yes, I think it was 15 or 16 that we learned that, yeah.
So why didn't your client serve or give some sort of notice to the fund when going through that process? That feels to me like it would have set it up a lot like the Vincenzo situation. And since the fund participated, they wouldn't have had a very good out.
They won't participate. The end of my appendix, there's a letter from, I believe it's the associate director, saying that we're not, until you get an order and serve us, we are not an interested party in AHD proceedings. We're not an interested party in OWC proceedings. And that's from another case, but I've done this many times. I filed for a formal hearing in this case and listed them as an interesting party. They're not going to participate. AHD won't hear it. There's nothing in the regulation.
At that point, you could make the argument that they waived their right to participate, right?
Yes, I think they've waived it completely in this case and in all cases. And I looked through the precedents. There are a number where they are participating. I don't know.
So were they
How they
given
claim it.
notice in this case for the informal
that?
process? Was the fund given notice in this case for the informal process? I didn't see that in the record.
I don't think so, Your Honor. It's
Okay.
been a number of years. And I believe this conference was around the time. And I communicated with them about whether their investigations had revealed that they're insolvent or not. And back and forth. And I actually went to their location, photographed all this stuff, but like, I can't recall when exactly I was conclusively sure that the special fund was in agreement that they were insolvent. But procedurally, it wouldn't make any difference because if I ask them to participate, they will not participate. That's been my experience. So, and with regard to healthcare, he can't get any healthcare because he doesn't have insurance. The act prohibits anyone else from paying for healthcare in a contested case, which is a peculiar feature in the regulations, not the act, but the regulations. And so our medical expert is the only option that we have And what Dr. Pabla said in, I believe it was 2022, is that he can't use his left hand essentially. Disability is an economic determination, so he can't really say whether he can work or not. That would be something beyond that, but he gave him extensive restrictions. And that wasn't even in the time period in question. So even if his hand had somehow healed, that wouldn't have anything to do with the judgment that was already issued by the Office of Workers' Compensation and defaulted on and supplementally given a Superior Court order finding that they were in default. So his hands are completely tied. There's essentially the act allows him nothing he can do. And I brought this before the court because the special fund cited Hardy for the a position completely contrary to what the CRB had held in Hardy. And then the CRB approved and ignored all of its precedents. And again, one of its subsequents and the Longshore precedent. And so I brought it here. And I did not intend to raise the issue of the constitutionality of the background process. I think if this court wants to entertain it, it clearly is contrary to his due process rights. But the essential issue that was initially brought is that if the special fund will not agree to participate and we get an order that's establishing it, and the CRB has said that OWC orders are just as good as AHD orders, and this court has found the same in a number of cases, most recently Melvin Schwechter, and he can't relitigate those cases according to the Byfield decision in 2021. There's nothing, we can't go to AHD and say, hey, he was disabled from 2015 to 2019. That has already been decided. There's an order regarding that, and AHD will not entertain that. CRB has approved that in the Byfield decision. So in essence, there's nothing that can be done. And the act does say if the special fund for some reason is short on money, then they have some discretion to deny benefits and they need to explain the reasons. But it does not give them the right to act as adjudicator of his right to benefits and as an entity that's an adverse party calling into question the benefits, especially for a time period that's now 5 years after the close of the ordered time period, where the question is a completely different one, whether he's disabled in 2024 versus whether he was disabled then. And not saying we're going to stop pursuing these. And I think there was a question about discretion to find a different type of ordered benefit. I think that is barred once there's an order. A scheduled award would be warranted if he returns to the workforce and reaches maximum medical improvement. But
Right, I mean, that follows from your general argument, they can't look behind it at all, so obviously they can't change it in that way, but if assume for a moment that a court were to conclude that they do have the ability to look behind the order, would you think as a fallback that they would have discretion to not have only the option of either accept the order in its current form or give zero? But assuming they do have some ability to weigh in and look behind it, would you think that they have only a binary choice of 0 or 100, or they might be able to either change the amount, choose to pay, exercise discretion to pay the amount, a lesser amount, but the same type of, same category of disability or change? Or do you also agree that even as a fallback, you think even if they can look behind it, their choice would only be 0 or 100 of the exact same type of benefits?
Your Honor, I think they have discretion in this case to treat the temporary total disability sum, which is 43,000, and the penalties, which are about 70, differently. Because the penalties are for the bad faith actions of Long Brothers Cleaners. And so the question of district's responsibility for that, given if they have an appropriate appeal to discretion, they can treat that differently in that sense. But whether they can question whether he was temporarily totally disabled when OWC and Superior Court have established by order that he was, no, I don't think they have any authority to do that. In theory, if we get a judgment for $43,000 and they have 35 in the bank, then yes, I think they might. I think that would be a case by case basis. If they have 80 and there's someone in a wheelchair and someone with a mangled hand, then perhaps they can point to the resources and give a reasoned explanation as to how it should be proportioned there. I have no idea how much money they have because they didn't say anything about it in the judgment. That's the sole discretion that they're granted. They didn't say anything about that. But they can't change the kind of benefit that was ordered, no. And they can't reinvestigate whether he was temporarily totally disabled, except with certain exceptional cases, I guess, if they want to try and set aside a judgment, but I think the time for that's passed. So no, I don't think they have discretion to review judgments that have already been established.
Thank you, counsel.
Thank you, Your Honor.
Appreciate your arguments today. This case will be submitted. The next case on the calendar today is 22 CF 447. Robert Wilson Dean Jr. versus the United States. Give everybody a minute to get set up. We have counsel for appellant and then we have amicus. So I'd be interested to hear how you're going to split your time and let us know how much time you'd like for rebuttal.
Your Honor, Fleming Terrell on behalf of Amicus PDS. We've agreed that it makes sense for PDS to argue first to address the legal issues before counsel for appellant discusses their application in this case.
Whenever you're ready.
I was hoping it would raise more. May it please the court. Again, my name is Fleming Terrell on behalf of Amicus Public Defender Service. I'd like to reserve 3 minutes of my time for rebuttal. I'd like to address 3 fundamental points that PDS believes will aid this court in resolving Mr. Dean's appeal, and that we submit it's critical for this court to clarify in order to avoid the misapplication of the Fourth Amendment principles recognized in Burns by judges issuing cell phone search warrants going forward. So let me just say what those 3 points are. First, Burns is binding authority, that the Fourth Amendment's particularity requirement mandates that a cell phone search warrant must specify and be strictly limited to the particular items of evidence the affidavit makes out probable cause to believe exist on the phone and have a nexus to the crime under investigation. A warrant for all records related to the offense under investigation does not satisfy that requirement. Second, to the extent the government relies on JFS and Abney to suggest that a different substantive rule of particularity applies when the cell phone belongs to a suspect, it misreads Burns and ignores Riley and other established Supreme Court precedent distinguishing probable cause to arrest from probable cause to search. Finally, the government's stated practice of executing all cell phone search warrants by not only extracting a full copy of the phone's data, but then taking the additional step of translating every byte of that data into human readable text and exposing all of that text to police and prosecutors involved in the investigation with no regard for the warrant's date or content limitations is unreasonable and violates the Fourth Amendment. So I'll take those in turn and I'll go back to the particularity rule to begin with. Burns simply articulates the Supreme Court's long established law of particularity and applies it to the modern context of a cell phone search warrant. Its particularity rule does not stand at odds with the Supreme Court's decision in Andresen. This is an issue that the government has raised yet again. It was litigated at length in Burns itself and raised in the government's petition for rehearing in Burns, and neither the panel nor the en banc court was swayed. And that's because Andresen did not hold, as the government insists it did, that a warrant limited to searching for evidence of a particular crime is always going to satisfy the Fourth Amendment's particularity
Can I ask you a
requirement.
hypothetical to, I find this this topic very difficult, so maybe you can help me with this hypothetical. So imagine that you're a detective and you're interviewing a suspect whom you have arrested, and you have probable cause to believe that the suspect committed a murder, let's say. And you have seized the suspect's cell phone. And after a valid waiver of Miranda rights, you're questioning the suspect, and you say to the suspect, let's say the suspect admits involvement in the homicide, but maybe is suggesting possible self-defense or something like that. And you say to and assume it's a domestic situation, so there was a romantic relationship between the suspect and the victim. And you say to the suspect, is there evidence of this homicide on your phone? And the suspect says, yes, plenty of it. And then you want to go get a warrant to search the phone.
Mhm.
What would a particular, how would you draft the warrant to be particular in the way that you think Burns requires particularity?
Right. I think to begin with, you would include in the warrant affidavit those facts that you just stated. And those are sort of particularized facts giving police probable cause to believe that there's going to be evidence on the phone, and likely not enabling them to say what
in
that evidence would be.
universe does the detective say, is there evidence on this phone about the homicide? The defense says, yes, plenty of it. And then the detective says, great, and goes off and signs out
Yeah,
the
but
warrant.
Here's the
I mean-
universe where the detective says, what, and the defendant says, I'm not going to get
I'm
into
not
that.
going to tell you.
That's
Right.
the universe.
So-
It's all hypothetical, but the
Okay.
issue is just trying to get into the question of sometimes you may have reason to believe a thing is in a place, but you can't be very particular about where in the place it is. And in the real world, in non-electronic settings, there's a set of there's law about that. How transferable that is to the electronic setting is debatable in light of Riley, and that's the hard, one of the hard questions that Burns starts grappling with. So I get all that.
Right.
But I'm just so just to imagine we're in this world where that's the follow on to what in any event is kind of a somewhat implausible hypothetical even before you add that feature of it. But like, what is it? What do you think that a particular warrant would say about what you're going to do in terms of searching on the phone for the plenty of evidence of the homicide that you have probable cause to believe is somewhere on the phone? What would a particular warrant say?
Right. So I think the rule that helps with this scenario is one reflected in Andresen. It's one that Burns said is, also reflected in some of the federal cases the government relies heavily on, Bishop and Bass and cases of that ilk, which is that the warrant has to describe the targets of the search with as much specificity as is reasonably possible under the circumstances. So the circumstances that you raise are quite distinctive and unusual. And perhaps there is an argument to be made that under those circumstances, it is not possible to state anything other than any evidence. If there is probable cause to believe that there's going to be
Sorry,
evidence on
I
the
just
phone.
need
And
to jump in. I mean, if we go old school and say we're talking about the search of someone's home
yes,
and we have the same facts.
yes,
Where the detective says, is there evidence that you committed this homicide in your house? And the defendant says, yes, plenty of it, and refuses to say more. Are there cases that say, toss the entire house? You can look anywhere and everywhere for whatever, because he said plenty of it. So that's as much as we can get.
right. No,
But is there authority?
not that I'm aware of. I don't
Okay,
think there
wasn't
are. And I
aware
would
of it, so I was just sort of.
I would be surprised to find that.
No, my
and
question
I-
is about authority. My question is just I'm just asking you, if you're a detective, what do you think the right answer to that question is?
Right.
Leave aside authority in the real, in non-electronic searches or in electronic searches. And the answers could be different because there are definitely some reason to think that there may be different rules in the electronic setting. I mean, that's
Right.
part of what Riley is about. So I get that. But in either setting, what do you think, leave aside I'm not sure there's case law about any of this, but what directly about it? What do you think the right answer is, either under conventional principles or under those principles as you think they should be modified in the electronic setting?
Well, again, I think the answer is it has to be reasonably specific as to what's on the phone. I think there would be a good argument that we would probably make that an experienced homicide detective would be able to state reasonably state some list of things that one might expect to find on a phone evidencing a homicide. Now, that's not enough by itself to provide probable cause to look for those items, but where in a unique case like you described, where it would be combined with a statement from the suspect that I have a bunch of evidence on my phone and I'm not going to tell you what it is, perhaps that would be a way for the police to reasonably narrow a list of what they should be looking for on a warrant. I want to add two things about electronic warrants that I think impact that analysis. One is, as Riley recognized, cell phone search warrants, searching them is an even more invasive and intrusive search than the most invasive search of a home, because of the vast quantity of information about sort of every aspect of daily life that they contain. So additional caution, additional restraint is warranted when searching a cell phone, even versus a home, for a broad array of evidence. And the other thing about cell phones is that, unlike a phone, the government extracts a copy, has a full digital copy of the contents of the phone, and they have exclusive access to it. So it is not like a home search where they have one opportunity to go in, find the evidence, and if they don't find it in that one opportunity, the defendant or the suspect can go back in the home and, toss the gun in the river because the police didn't find it. The government has full access to the digital information. It's safe. It's not going to be altered, and they can go back and get sequential warrants if, for example, they seek a reasonable list of communications regarding the suspected murder, et cetera. In the case you describe, they go in, they don't find anything, then they have probable cause to think, well, there must be something else here, and they can go back and get an additional warrant for that. And I think that comports with the Fourth Amendment case law that says, in executing a warrant, police have to look in the reasonable places first. You can't go looking for a lawnmower in the attic in the first instance. So I think those principles would restrain a search, even in the unusual circumstances you describe.
Although, I mean, again, some of this may be about what special rules should or to a degree may already have been created for electronic searches, but I'm curious, I have the impression, you can correct me if you're wrong, if I'm wrong, or if you have a different impression, that in conventional searches, if let's say the police have arrested somebody for a homicide that involved a gun and they haven't found the gun yet, and the defendant was apprehended some days after the shooting. So the idea is, well, maybe the gun is at the house.
Mhm.
Let's assume for a moment there's probable cause to believe the gun is at the house, all things considered. And the police get a warrant to search the house for a gun. Is it your view that a warrant authorizing that search needs to be more particular than the house, saying we're looking in the house for the gun, but needs to be more particular about where in the house one's going to search? So for example, it would say, we plan to look in plain view and in any place that would be big enough to hold a gun. We don't plan to open any salt shakers because, of course, the gun isn't going to be in a salt shaker. Do you need to have, in your view, or is in your belief, in the conventional setting, again, special rules may be necessary and appropriate in the electronic setting, but is that an aspect of particularity in the ordinary context in your view, or is that not really so much a non-electronic concept, and this is more a special set of rules about electronic searches?
Right. I think with regard, so I should say, I'm not proposing a different set of rules for the electronic context. But I think with regard to the physical search of a home, generally, I think stating the address of the home is sufficient. If it's a multifamily house, if it's a very large property, there might be circumstances where that would not be as particular as is reasonable necessary. I mean, keep in mind that the purpose of the particularity requirement is to ensure that those executing the search stay within the confines of the probable cause that's been shown, right? That they don't go looking for or seizing evidence.
Well, it would have been reasonably necessary in the hypothetical I just gave to say at the front end, we're only going to search the house for places where a gun could be, and we're not going to search in places where a gun can't be. So all containers smaller than the size of a gun will not be open.
Right.
So you could be more particular. It's reasonably feasible to be more particular.
Right. Right. You certainly can. There's no harm in that. And I think perhaps what Your Honor is getting at is the question about search protocols in electronic search warrants. And I want to be clear that it is not our position that the Fourth Amendment requires in every case that there be ex ante search protocols.
That's an aspect. That's an implication of what I was asking. But my question right now is more focused conceptually on how stringent the particularity requirement generally is outside of the context of electronic searches. And I guess I have the impression Though can't say I've independently, tried to run this down, but I have the impression that in the context of non-electronic searches, it would be, well, it depends how stringent a concept you think reasonable necessity is, if that's the phrase. But it seems to me that search warrants for physical objects in places like homes are generally not very particular about where in the home to look, and that that's thought to be fine in the non-electronic setting.
I think, Your Honor, that they don't need to be, and that's because they specify what the object is. When you say what you're looking for, what you're authorized to search for is a gun, that tells those executing the search where it is reasonable to look for and not look for that. And that's why, and I want to be clear that when, Burns, I think rightly conceived.
Well, but I thought the particularity requirement, I mean, I get that line of thought. That's a fair comment, but part of the particularity requirement is because you're not so sure that law enforcement officers who are engaged in the competitive exercise of ferreting out crime are going to make good judgments about that. So you want the warrant at the front end as an authorization from the judge to impose reasonable limits, not sort of say, well, you know what you're looking for, so just go look anywhere where what you're looking for is found. So the particularity requirement is partly intended to not rely solely on what officers might infer about where to look for things.
Well,
But the question is how stringent a requirement is. That's what I find.
right.
difficult.
It's meant to leave nothing to the discretion of the officers. And I think that the point that I want to make is that I think Burns rightly conceived of the particularity that is most critical in the context of a cell phone search warrant is particularity as to the item that is being searched for. That is the piece of information that police are authorized to search for. And that is a prerequisite.
So let's say a different hypothetical. Imagine again in a situation where A is charged with killing B arising out of where A and B had a prior romantic relationship of, let's say, 6 months. And say that a detective applies for a search warrant and says, tries to be very particular and says, I would like to get all texts between A and B during that 6-month period, all phone messages that were left from A to, I forget who's B and who's A in that, but all photos during that time period that depict both A and or B, or maybe just B, the victim, who knows, but assume there's probable cause for each of the categories I listed, which you may or may not agree with, but assume for a moment that there was probable cause in a case like that to look for those things.
Right.
Would you think that's sufficiently particular, or do you think more needs to be done?
If it says, I think that's not sufficiently particular. I don't know if I heard a date range on that.
Yeah,
but-
as within the 6-month period.
Right. I think that's fine. And I think that goes to the point that, the government has suggested that we're saying that a digital search warrant can only be for evidence the government knows for a fact to exist on the phone, right? Only the specific text. That's not our position. Our position is that there has, just as with a physical search warrant, there has to be a showing of probable cause to believe there is either a particular item or a category of items. So here, perhaps, for the sake of argument, let's say that it is reasonable, it is substantially based in fact to infer that people involved in a 4-month relationship are going to be communicating with one another over the course of that relationship, and that those communications would be relevant to the investigation of a domestic violence homicide between them. Then it could be under those circumstances sufficiently particular to state in the warrant. So communications, email, text communications between party A and party B over the course of the 4 months leading up to the homicide. It can be a category of information, but what it can't be is those communications and any other information related to the homicide, because there's been no probable cause for the existence of any other information related to the homicide. And when you're talking about a cell phone, you're talking about a vast warehouse of varied private information, intimate information about the owner of the cell phone.
I get that, and I'm interested in, to the extent you were suggesting a little bit ago that you're not asking for a special, or not advocating that the court adopt special rules relating to particularity in the electronic setting. The point you're just making now, how would you square it if it's not a special rule relating to electronic searches? How do you square it with Andresen?
The point that you can't also say any other evidence. So I think Andresen, first of all, wasn't presented with that question. Is it sufficiently particular to have a warrant for any other evidence or any evidence of an offense? The question presented in Andresen dealt with a warrant for a very detailed itemized list of real estate transaction documents that there was probable cause to believe would have been generated in the course of this real estate fraud, to search for those documents in paper file cabinets. And then the question that the Supreme Court was presented with was whether at the end of that list, a catch-all to also seize other fruits, instrumentalities, and evidence of crime at this time unknown was an impermissible general warrant to search for evidence of other crimes besides the real estate fraud that was the subject of the investigation. And in that context, the Supreme Court said, no, we're going to read this catch-all as referring just to other evidence of the same ilk as the documents that are meticulously described in the warrant and relate to the offense under investigation. As Lefebvre said in discussing Andresen, and this is in section 4.6D of the search and seizure treatise, that decision should not be read as expressing general approval of the use and search warrants of such loose and unconfined descriptions as any other evidence. I think it reflects, and Lefebvre points out, it reflects that the description sufficed because it was the best that could be expected under the particular circumstances. That's consistent with the rule that I mentioned earlier, that Bass and Bishop and Burns recognize that a warrant needs to describe the search targets as specifically as reasonably possible. And when you are talking about a search in an electronic environment of a cell phone, it is not reasonable to be so vague about what you're looking for,
I
right?
mean, that's
Because of
my
the-
question. Andresen is like 1979 or something,
Yes.
right? So, I mean, fruits, instrumentalities, I can't remember what all the other language was in the catch-all that they said, okay, as long as it applies to the real estate fraud venture,
Yes.
right? And what if it's 2024 and they're executing this warrant? Are you saying, does Andresen stand for the proposition that if those fruits instrumentalities were on a hard drive of a computer in the home, that they could look not only for the documents in the file cabinet, they could search the entire hard drive, they could look at,
No.
okay, right?
don't think
I
so.
mean, how helpful is Andresen, I guess, is my
It's
question.
not. I mean,
because
Andresen-
it's from a lifetime ago.
It is, and even there, the court was careful to note that there are grave dangers involved in this kind of document review because it involves the review of every single document. And that's where you have a relatively limited universe of paper files in a real estate lawyer's filing cabinets. Adding any other evidence after this extensive list of particular, lien memoranda and closing contracts doesn't, I think in some of those physical searches, the function of those catch-all, any other evidence provisions was to ensure that if in the course of conducting a search for the itemized evidence, police come across other documents of the same ilk that aren't specifically described in the warrant, that there won't be a question about whether it's within the scope of the warrant for them to seize that. What it doesn't do is expand the scope and intensity of the search that's necessary to find the evidence described in the warrant, right? Because we're talking about papers in a file cabinet. That's all, the police are already going to be reviewing all those papers, looking for the 15 different types of documents about the real estate transaction described in the warrant. So this additional catch-all doesn't really change very much about the way that the warrant is executed. In a digital environment, it dramatically changes how the warrant is executed. Imagine a warrant here just for communications with the decedent over 4 months preceding the homicide. That would not authorize a search of photographs, of web browser history, of medical portal information, of banking information. But if you expand that search to any other evidence of the homicide, well, as the Supreme Court pointed out in Riley, any officer can come up with reason to believe that there's all sorts of evidence on a cell phone that would relate to any given crime. And so for those reasons, Andresen really does not provide any guidance and certainly doesn't provide the blanket authorization that the government insists that it does for cell phone search warrants that are restricted only by naming the offense in
Can
question.
we drill down a little bit? I mean, maybe this is sort of shifting over into probable cause a little bit, but I think it implicates particularity too. Right, so, I mean, if we're looking at attachment B in this case, the communications requested or covered in attachment B or communications relating to the offenses described in the above affidavits and including communications among accomplices, right?
Right.
I mean, the communications relating to offenses described in the above affidavits, like, what does that mean? And what do you think the probable cause was to support that request?
I don't think there is probable cause to support that request.
Well,
I
there's
think-
some problem, right? That we know there's some communications between Mr. Dean and Mr. Morris,
Yes.
right? So there's probable cause to believe that there's communication between those people. Does that give the government probable cause to think that Mr. Dean is communicating with others about the offense?
No, I don't think so. I mean, probable cause requires, a substantial basis. In fact, it can't be mere speculation. It can't be conjecture. And just because someone is communicating with witness two doesn't mean that they're sending other communications related to the offense. Indeed, here, the government had the cell, the call data logs from the cell provider and make no mention in the affidavit that there were any other communications around the same time with other individuals. Maybe if they had, there could be arguably probable cause.
Right,
that-
but it sort of wraps up in like, well, they don't know, right? I mean, they're still investigating, so, it does. I know you disavow saying they only have probable cause to look for the things that they already know about, but why is that not the case?
Well, I think there would be probable cause to look for communications with witness two. Now here where you have witness two
Witness two is-
who's shown his phone
It's
and
Mr.
said,
Morris, right? So are we allowed to
yes,
say that
yes,
now? Okay.
who's shown his
Yeah.
phone and says, this is the only communication going back and forth. They've got the call data logs that corroborate that. I would argue that it is still overbroad to say any communications during that window because the police are reasonably able to be more specific about what they have probable cause to believe. is
And that's
innocent.
shifting over to particularity a bit rather than probable cause for sure. But just on the probable cause side, do you think there was probable cause or, well, I guess there are slightly distinct questions whether the affidavit established or whether a reasonable affidavit could have established. But do you think there was probable cause to believe that there were communications between the decedent and Mr. Dean that would be evidence of the crime?
I don't think on this affidavit that there was, and again, that's because the affidavit represents that the police have call data records from the cell provider indicating the communications
Are you
traffic.
drawing some kind of negative inference from what's not in there or something? I mean, fair enough.
Right,
They could have probably done
right.
better, but that's not really
Exactly.
generally the metric.
My point is that
Probable cause.
in light of that, I would argue that there was not probable cause. The government certainly didn't lay out probable cause based on the information that they had for communications. There is I recognize there is certainly an argument. I might lose that, right? There's certainly an argument that where you have people involved in a romantic relationship, they are likely to be, and they own cell phones, they are likely to be communicating with one another. The affidavit doesn't lay out evidence that the decedent had a cell phone. So that's one issue. But assuming that there was probable cause for those communications, it was entirely possible, and we know this because the government does it in its brief, to say there was probable cause for communications between these two individuals over the course of this 4-month relationship. So we are authorized to search for those. There was no need to include these overbroad and non-particularized authorizations to search, certainly not for any and all evidence of the murder or even for any and all communications related to the murder.
Counsel, in your view, and I will say a hypothetical or a generalized world, if the time frame shifted down dramatically, like if we said, we know people put evidence on their cell phones, this happened on X day and we did that day plus 2 days in either direction. In your view, would that give the government a broader leash?
I don't think time frame enough is sufficient to satisfy the requirements of the Fourth Amendment. And that's because, I don't think we can infer from the mere fact of probable cause to believe someone committed a crime and the fact they possess a cell phone, that their cell phone will contain any particular evidence of that crime. There is a strong temptation to relax the requirements of the Fourth Amendment based on the instinct that we all have that people's phones, by the very fact of their the range of information that they store will have some information about a crime.
Well, we see that
stored somewhere.
repeatedly in the affidavits across cases, whether Burns, JFS, this case, et cetera, that people tend to take trophy photos and other things on their phones. Certainly, I don't imagine the person taking a trophy photo in this case, but that seems to be boilerplate that's made it into these.
Yes.
Isn't the phone starting to look I don't know what a great analogy would be. If I was looking for a gun, a phone seems to me, based on the affidavits, not to be so generalized, but something more like a gun safe that someone might reasonably store that in.
Well, I think the claims about trophy photos based on police training and experience may be a slightly different case, although I would urge the
That's not
court.
in this affidavit.
That's not in this affidavit. There's no gun in this case in any event. There's certainly not a claim that, based on my training experience, people who commit homicides with screwdrivers take trophy photos of their screwdrivers. So I don't think there's probable cause to look for evidence.
No, certainly not
screwdriver
relevant
ownership,
to this
but-
case, but like Google searches and things like that.
There are, right, so there are a lot of claims in these warrants that we see that appear to be copied from one warrant to another about, based on police training and experience, that people who commit crimes do all kinds of things on their phones that reflect their activities, their locations, et cetera. That is true because everyone does things on their phone that reflect their activity, their location, et cetera. I think the government has acknowledged in its brief that those are really just sort of common sense assertions about how people use phones. I don't dispute that training and experience can provide an important lens. Police training and experience can provide an important lens through which to view facts in the affidavit, but it is not itself a fact that adds to the probable cause, and it needs to be supported. Police need to be able to explain the basis for that. Here, it is just the general intuition that people use cell phones in a bunch of ways, and I think inferring probable cause from that fact is speculative and conjectural and would fly in the face of Riley, because what it would mean is that in every case where you have someone who is a suspect in a crime who has a phone, there would be probable cause to believe that their phone will contain a variety of evidence about that offense. And that would turn Riley's insistence that police get a warrant before searching arrestees' phones from a meaningful constraint on the government's ability to rummage through these private spaces into a mere paperwork requirement.
Well, I mean, I get your point in part, but I think it understates the importance of the warrant requirement to refer to it as a mere paperwork requirement. It's understood to be a very important protection, even where probable cause exists. So it's not like, it's just a piece of paperwork where it's applicable, even if it does authorize searches. It's thought to be very important to make sure that you get judicial approval at the front end and with appropriate limitations. And even if there might well be categories of things where it's obvious there's probable cause. You could say about in, I guess, Warden versus Hayden, I think it was, where the Supreme Court says we're not going to have a crime scene exception to the warrant requirement. Well, you're going to be able to go get a warrant to search the crime scene. That's not going to be hard to do.
Right.
But that doesn't mean it's meaningless to require it. It's still thought to be an important requirement, and it's not sort of inconsistent with requiring it that, in fact, probably you will be able to have probable cause to search a crime scene all the time. So it might be a bit of an overstatement to make it a meaningless paperwork requirement if it's relatively easily satisfied, practically speaking, given the way people use their phones.
I think we've cited in one of the footnotes in our brief, a number of courts that have had that understanding of Riley. And the point is, the reason that you have the warrant requirement is to impose that meaningful constraint by restricting the search to what there's probable cause to believe is there on the phone or is there at the crime scene. And if you allow probable cause for certainly what the government suggests is that where you have a suspect, that alone is enough probable cause, certainly in combination with these sort of generic statements based on police training and experience about how people use phones, that alone is enough to support exactly the kind of warrant that Burns said violates the particularity requirement, a warrant to search for any and all evidence of the offense, because there's probable cause to believe there's such a broad range of evidence on any suspect's phone. And that is the inference that I'm saying, if this court were to adopt that inference, that would thoroughly undermine Riley's insistence on the warrant requirement as a meaningful constraint on law enforcement's ability to search arrestees' phones. Because as Riley pointed out, police can think of plenty of reasons to look for, to believe that there would be evidence of even the most minor offense on a phone. That's not good enough. They still need to go and get a warrant and show probable cause.
Can we go back to, I guess, particularity again, and just on the question of communications, for example, when we say, okay, there might be probable cause to think that there are communications between Mr. Dean and Mr. Morris, but do we care about the type of communications? For example, Mr. Morris shows the police his phone and he seems to be using, the normal sort of text app.
Mhm.
But does that mean that there's probable cause to look for, or should they be saying more particularly that they want to look not just at the text app, but also WhatsApp and, any, Facebook Messenger or any other sort of communication type platform that could be on the phone?
Right. And in a case like this, and some of the others that have come before the court, where the probable cause to believe that communications exist arises from the other party to those communications showing the police, here are the communications.
Right.
Then I think the particularity rule requires the warrant to specify what types of communications they are. So SMS messages, or if they were WhatsApp.
So if Mr.
whatever.
Morris had just said, we spoke on the phone and here's my call log, but there had not been any texts, you would say there's not probable cause to look at the texts on Mr. Dean's phone.
That's correct.
I know you had 3 points you want to
You
make.
might- if I
To be on
could-
point number one, and about point number two, I had a question about how you formulated it. So,
Okay, so go ahead.
the way, as I recall, so you correct me if I'm misrecalling, your point was, don't misinterpret JFS and Abney to say that there are special particularity rules that are more lenient in cases involving suspects as opposed to witnesses.
Right.
And I guess I thought that JFS and Abney don't decide that question.
They
They
don't.
decide a related question, which is whether that distinction is sufficient that officers before Burns, in a case involving a suspect, could rely on what seems like a pretty unparticular warrant after Burns.
Mhm.
It's such that exclusion is not, a suppression of evidence is not warranted under the exclusionary rule. And so I wouldn't be very inclined to interpret JFS or Abney to say anything direct about what the actual particularity requirements are in a case where there's robust probable cause to believe there's a range of evidence on a phone, which you could debate whether this case is that or isn't that.
Right.
But so fair enough, not to misinterpret them that way. I completely agree. You shouldn't understand them to even decide that question. But what they do decide, and what I'm interested in your views about, is the related but distinct question of whether what they say about what reasonable officers could have relied upon before Burns was decided about what degree of particularity is adequate or required in a case involving, using the words of one or both of them, robust showings of probable cause for a range of evidence on a phone.
Right. Okay. So I'd like to, I'll answer that, but I first want to say, the concern that we have about JFS and Abney is that they, while they were very careful to restrict, to say that the decision was restricted to the good faith analysis, they discuss particularity, they discuss probable cause, and they place a very heavy emphasis on Mr. Burns' non-suspect status as distinguishing the case. And then, I think that can cause confusion. And I would urge this court to clarify that those cases do not mean that in the case of a suspect, there is a different particularity rule, or there is this just assumption of wide-ranging probable cause. I would just note, we disagree with those decisions' emphasis on non-suspect status as a basis for even the good faith ruling, because for a variety of reasons, first and foremost, Mr. Burns, while nominally not a suspect, was deeply implicated in the murder of his best friend in his apartment after he and his family had flown his best friend to DC. And when he had what the government described in that case as a shaky alibi, so implicated that the government took the position in Burns that there was probable cause to believe Mr. Burns was either the perpetrator or the intended target.
That sounds like you might be disagreeing with the majority of the court in Burns, which concluded otherwise with respect to those arguments.
The majority of the court in Burns did not mention suspect status
No,
until,
with respect to probable cause,
Until
the
the-
government argued there was broad probable cause to believe that he was a suspect and there was plenty of information relating to his status as a suspect. I thought the court did decide that there was probable cause limited to his status as a potential witness, or am I misrecalling?
the court decided, so in its probable cause assessment, the court didn't refer to his status as a non-suspect or as a nominally as a witness at all. In its particularity assessment, it didn't refer to that status. It didn't rely on that as a basis for finding limited probable cause or as a basis for finding that the warrants were overbroad and lacking in particularity.
I just want to make sure I
And-
get you on the first of the things you said. I mean, I think it's right in, as I'm recalling, it's correct in a respect, but I'm unsure about it in another respect. So I think it is correct, as I'm recalling, Burns, that it doesn't, when it's saying how limited probable cause, it doesn't say. And so what we're saying is that there was only probable cause to, the things that there were probable cause for all arise out of his status as a witness rather than as a potential suspect. So that's fair. But is it true or not true that the things that actually were, the court held, the items as to which there was probable cause, all were items that in fact connect to his status as a potential witness rather than a suspect?
Well, the Burns court the reason that it didn't mention suspect or non-suspect status is because of this fundamental Fourth Amendment sort of Hornbook law that probable cause to arrest is not the same as probable cause to search. And
No, I
Right, and
get that, but if I'm just asking a sort of a question, which is, do you recall the exact items? that
the
in
items were
Burns that-
communications with the decedent in the hours leading up to his death, text messages, sort of supporting Mr. Burns' shaky alibi, right? And the log of a phone call with his cousin that was, again, part of that alibi to verify the alibi. So those are exactly the kind of evidence that police would be searching for in the case of a suspect. And the government certainly argued vociferously in its Burns briefing that police were entitled to look in, to check that alibi, right? I want to be really clear that Burns relied in concluding that there is limited probable cause and in concluding that the warrants were insufficiently particular on cases invalidating warrants to search suspect's cell phone without drawing any distinction between those cases and the facts of Burns. So I think the fact that Mr. Byrne was nominally a witness and not a suspect was thoroughly immaterial to the probable cause or particularity analysis, as it should be in every case, because the inquiry for a cell phone search warrant is the probable cause to believe there is evidence on the phone. The only mention of suspect status came at the end of the good faith analysis, after the court had already said these warrants are too lacking in evidence of probable cause to support good faith belief in their validity. Then it went on to say, and also they are too obviously lacking in particularity. And at that point is the only time when the court said, sort of in addition, the fact that Mr. Burns was nominally a witness makes it even more unlikely that the officers executing the warrant could have believed that there would be a broad range of evidence on his phone. So I think that intensifies the court's good faith ruling, but I think it was in no part fundamental to the court's decision on probable cause, on particularity, or on good faith in Burns. And my concern is that by focusing on suspect status, Abney and JFS have created a situation where courts can be confused by arguments like the one the government makes in this case, that because the subject of the warrant, because the person who owns the cell phone that is subject to the warrant is a suspect, that means there is such broad probable cause per se that the very kind of warrant Burns struck down is violating the Fourth Amendment to search for any and all evidence of the offense on the phone is somehow permissible. I think it would be important for this court to clarify that point in its opinion in this case to avoid confusion going forward, because while we are sort of running out of pre-Burns warrants to conduct the good faith analysis that Abney and JFS did, we will have years to come of cell phone search warrants issued under the Burns rules. And it is important to avoid that kind of confusion about what is and is not permitted under the particularity and probable cause rules.
Can we move forward to execution?
Yes, and thank you. I'll be brief on execution. I I think I've already said, PDS does not take the position that the Fourth Amendment requires search warrants to include ex ante protocols that are approved by the judge in every case, although, as we've noted, many courts and commentators have said that might be a good idea. Our position is simply that this approach, the prosecutor described as the pattern and practice of the U.S. Attorney's Office in these cell phone search warrant cases, is not authorized by Rule 41 and is not a reasonable manner of executing a cell phone search warrant where there are any limitations on the date or content of the data that police are authorized to search for.
And so just to drill down, I understand the AUSA to say, well, I don't actually remember what I did in this case, but my typical practice and what everyone does in the U.S. Attorney's Office is that we get the data extracted, then we get it translated into a PDF. DFS does all of this with the Celebrite software.
Mhm.
We get the PDF with all of the data, and then we kind of look through it and looking at the table of contents and, kind of looking at date ranges, we decide what we want, what's relevant.
Right. That's my
And-
understanding as well.
Okay, and so why is that not okay?
So the reason that's not okay is because when you have a warrant that's limited as here to 1 month of data, exposing to the investigator's view, data that is outside that range, that is clearly not responsive to the warrant, is unreasonable in violation of the Fourth Amendment.
So I'm
And
just
so
going
there's
back to my house example,
Yes.
and you have a warrant for documents in a
Yes.
filing cabinet for a date range. But you're exposed to all of the other documents outside of the date range and you just pick the dates within the date range. So why is this different?
This would be more like a warrant for a house where you send an officer ahead of the investigators to open every drawer, open every cabinet, lay open all of the diaries, turn on the videotapes, and then have the investigating officers walk through the house looking for the gun, right? It is exposing to police and prosecutors' view a great deal more evidence, a great deal of data in places on the phone where it is not reasonable to search for the responsive data. We've analogized this court to Arizona versus Hicks, which is a case where an officer turned over a stereo in order to reveal the serial code on the bottom of it. And the court held that that was an independent search because that action exposed to view concealed portions of the apartment that was being searched, that concealed portion being the serial code. And that was an additional invasion of the respondent's privacy interests. Here, I think, the government sort of collapses the procedure in its discussion of it. They talk a lot about how it's not technically possible to filter or restrict the extraction of data, the initial extraction of data from the cell phone. And we don't dispute that. We take them at their word on that that's what the technology allows. You have to make a full copy of the data on the phone, but that copy is, zeros and ones, it's code. There's a second step, which the DFS examiner described in her testimony here, where the analyzer portion of the Celebrite software translates that code into human readable format. And then
I'm just interested because it's a multi-step process and I'm curious where you think things went off the rails.
at
So
the translation.
is that step itself is unreasonable?
The translation step, translating all of the information. It's our understanding that the Celebrate software has the capacity, as described by the examiner here, has the capacity to generate a report, which is where a human looking at it can actually, for the first time, see the readable data, to generate a report that contains, for example, only SMS messages,
Right.
or only items dated between this date and that date.
Right.
And our contention is that is what the Fourth Amendment requires, is a reasonable protocol to execute.
Right.
a
One of the
self-research.
difficulties with that is that to a degree that turns on factual questions about the capabilities of software where no real record has been made. So that's a little tricky. So I get, that's a complication with implementing that line of thought on this record, but there's also the complication that if we're getting to execution, it starts wrapping back around to particularity and overbreadth of the warrant itself. And so if we're it's sort of simpler to think, imagine you had a warrant that actually was particular in
Yes.
your view.
Yes.
And was supported by probable cause with respect to what it authorized. Then that translation you think might be fine if there was a warrant that in fact had limited things so that what was generated by the translation was all within the scope of the warrant. So in some ways that gets a little bit, it's just a little
Yeah,
circular relative to the particularity probable cause problems.
I think Your Honor touches on a really important point, which is, there's going to need to be sort of litigation in individual cases in the Superior Court around exactly what is and isn't reasonable for executing these warrants, and that will change as technology changes. You can't even begin to have those ex post reviews that the government insists are the way for cell phone owners to vindicate their Fourth Amendment rights until you have a warrant that states with particularity what it is police are authorized to be searching the phone for. Because until you know what that is, you can't decide how it's reasonable to conduct that search. Just on your point about the technology, I think there's adequate information in the record here. Just the exhibit itself of the extraction report and the way that it is divided, which is consistent with how the prosecutor described it, right?
I just meant with respect to whether the second step is unreasonable itself because their Cellbrite has better capabilities to be more targeted. That seems to me not so clearly established. I understand later, you also think things went awry again at later steps, if I understand it. Like then even if that is the way, assume for a moment that on this record, we can't say that was an unreasonable way to do it because who knows, maybe it's true that Cellbrite has that capability, maybe not, I don't know. But let's assume for a moment that it was true or uncontested, that step was okay.
Right.
And then if the issue then is, okay, but then now there's this, first there's this logical extraction, which is step 2 really. And then there's the creating of the 14,000 page document, which is step 3 maybe. And then there's handing that to, or either picking somehow making that available to the investigating prosecutor rather than taint teams. And there you have, I think maybe issues with the reasonableness of several of those steps.
Right. I think the DFS examiner described the Cellbrite software sort of parsing things into different categories, but leaving that aside, even if Cellbrite has to spit out the 14,000 page PDF showing everything, that PDF we know because it was admitted into evidence at trial and we've supplemented the record with it here is divided by type of data, is organized chronologically by date. Even items that are deleted have a column that says this item has been deleted. The date is still there, right? It is unreasonable for the investigator or the line prosecutor to have access to that, to procure that full document, right? And flip to the pages that have those.
That gets you into taint teams, which are a really interesting topic. As far as I know, this court has never expressed a view in any setting about the extent to which taint teams are effective to avoid problems that might arise with respect to their primary area that I'm familiar with is in privileged settings. Courts around the country are somewhat divided about the extent to which they're effective or adequate to resolve legal problems. Right. It strikes me as somewhat deep water to jump into here about taint teams and the like. I mean, the perspective that the defense often has is, how does a taint team help? It's so some other prosecutor looks at it and then does or doesn't turn over things. None of that is really very protective or appropriate. So I'm a little unsure about how far to jump into the topic of taint teams.
I think one can get very deep in the weeds on this topic, but I think the point is exposing to the prosecutor or the detective's view a vast array of clearly non-responsive data is not reasonable. And whatever we know about how Cellbrite works, we know that here many thousands of pages of the data that were exposed to the prosecutor's view were not responsive to this 1 month range warrant. And we know that the government says that's their standard practice in every case, indiscriminately, regardless of the limitations in the warrant. The prosecutor.
I guess this is a little bit about maybe suppression, when suppression is warranted, when there are manner problems, but manner of execution problems. Is it your view that imagine that there was a 14,000 page document that was generated just like this one, but imagine it was very carefully chronologically organized.
Mm-hmm.
And imagine that the prosecutor said, let's say in a case where there was a fuller process under oath at a hearing, the prosecutor said, I received that 14,000 page document. I looked in the table of contents. I saw that chapter 13 was the month that I had, was the scope of the warrant. And so I took that and I read chapter 13 and chapter 13 only. would you say that is an unreasonable manner of execution because it really never should have been in the hands of the prosecutor? And B, that moreover, suppression of all evidence would be warranted because that manner of execution was so unreasonable as to require suppression not only of, you know, what was in chapter 13 that could have appropriately been read, but everything else. But I mean, it would require suppression of things outside chapter 13 if any had been found, but if the testimony is true, none was. But it would also require suppression of the material identified in chapter 13.
Yes, it's our view that, you know, this is not hard. When you start talking about tank teams, you know, it sounds very complicated and work intensive. You know, here it's about flipping to the date range. You know, the prosecutor described her protocol of, you know, flipping to a particular date range and looking at that date range. There's no reason that when she procured the extraction report that date range could not have been just pulled out of the document, right? I will note on even the table of contents reveals to view private information, what apps are on the phone, what kind of data is on the phone, how many text messages are on the phone. And then certainly when you flip to a page, you know, if you have a certain date range, maybe it starts in the middle of the page. So you're seeing things that are outside that date range necessarily. And it provides a great temptation, and it's just not a good position to put line prosecutors in to be doing this kind of flipping through this vast trove of information that the warrant makes clear they should not be having access to. And so we think that where you have a warrant for a month's worth of data and you get instead 14,000 pages of data translated into readable format to flip through it at your leisure. And I'm not suggesting that the prosecutor, you know, intentionally looked at anything she wasn't supposed to, but we think that is flagrantly exceeding the scope of this 1 month warrant, such that all of the proceeds of the warrant should have been suppressed. If this court disagrees, I think it would still be important for it to clarify in its opinion on this case that this protocol that the government has articulated as its standard operating procedure for executing cell phone search warrants is not authorized by Rule 31 and is not compatible with the Fourth Amendment in the vast majority of cases.
Let me ask you, taking it back a half step. So if in an ideal procedure, only the data that corresponds for that 1 month comes out, what would you have happen with the rest of it, whether binary, image data, et cetera?
I think there are questions that are not raised in this case about the retention of private information and how long the government, you know, this case sort of gives an example where there was a logical extraction of the cell phone, which is basically sort of looking at what the user interface of the cell phone would look like. And then technology improved and police determined that there were deleted items because there was stuff on the data from the provider that wasn't on the cell phone. And then they went back, they still had the phone and they were able to go back and get an additional warrant. I think will need to be some outside time restrictions on the government's ability to retain that information, some destruction protocols, et cetera. What those are, I think, is beyond the scope of the.
Yeah, I ask you that solely because I remember from another case that when they do a physical instead of a logical extraction, that in almost all cases destroys the phone. And maybe the technology has advanced past them, but it sounds almost like the example you gave very early on where the search of the house, they don't find the gun. And so then someone has the opportunity, and I don't know if the implication was that they should, to go toss it in the lake. It sounds like if they can't hold on to that data, they may get rid of it. But I take your point that it's not fairly implicated here by the parties.
I think that, you know, the touchstone of the Fourth Amendment is reasonableness, and there's going to be some point at which it is reasonable, you know, some period of time at which it's reasonable for the government to hold the physical extraction, the full data of the phone while they are investigating the case. And at some point, it will become unreasonable for them to continue to retain it. 10 years later, if there's another case involving the same person, probably the government shouldn't still have that copy of their cell phone that they can go back and look at.
It's a really interesting issue, which obviously we haven't litigated. I sort of thought that, I mean, the Constitution may speak to it too. Rule 41 does, in the sense that you can file a motion for return of property.
Right.
And so if you're a defendant and the police have your property and you want it back, you can file a motion under Rule 41 saying they don't need it anymore and they have no right to keep it and they're done with it and I should have it back. So there's a non-constitutional mechanism to assert that interest. Whether the Constitution itself kind of sua sponte has a time limit for unrequested return. It's a really interesting. I've never thought about that question before, so I have no idea. Is there a law on that you're aware of, or is that
Your Honor, I can,
I don't mean to, it's off topic, so really I don't mean to waste anybody's time.
I
with it.
think-
I would just say, I think it's a really interesting topic. I'm not aware of any law on it other than Rule 41 as a non-constitutional mechanism.
Right. I think near the end of our reply brief, there is a case cited. I want to say it's out of the Second Circuit that talked about the reasonableness of retaining this kind of information for long periods of time, but I'm getting pretty far out over my skis on that.
Council, we are going to let you sit down. Thank you very much.
Thank you.
Hear from Ms. Walton.
Morning, Anne Keith Walton on behalf of Mr. Dean.
It is still morning, yes.
Is it still morning?
Barely.
And I'll reserve 3 minutes for rebuttal. And on behalf of Mr. Dean, I concur with the arguments made by the Public Defender Service. And I respectfully request this court to reverse Mr. Dean's convictions based on the trial court's error in allowing the admission of this evidence taken from Mr. Dean's cell phone. And I have 2 main points. And of course, the first is the probable cause and particularity issue. And then the second is the procedure taken by the prosecutor in this case with regard to the Celebrate report. So beginning with the actual warrant and the affidavit, the probable cause, there was probable cause to search the text messages with Mr. Morris and the call log and the location data from between March 31st to April 5th of 2018. It was pretty narrow, the facts set forth in the affidavit, even though the detective did have 2 years to add to the probable cause section and the affidavit. He chose not to. And there was nothing, for example, about Ms. McNeil or Mr. Lewis in any interaction with Mr. Dean with those 2 witnesses. And there was very limited information about the relationship with Ms. White, the decedent. And certainly nothing to justify a search back to March 1st, 2018. That it appeared to be a somewhat arbitrary date that they picked. My argument is that it should have started on March 31st based on what was set forth in the affidavit. And then turning to particularity.
Just on the probable cause. So if I recall correctly, it came to light that there was an incident on the 18th, I think, March 8th, between Mr. Dean and Ms. White. Is that in the affidavit? Do they talk about that incident?
No,
No.
they don't. No, and so that's, that's a different issue. If that was in there, obviously that would bring, I think, the search back to March 18th. There was really nothing about.
Would you say, just because there had been an incident, would that bring in? I guess I'm wondering, why do you think is there probable cause to think that there are any sort of communications between Mr. Dean and the decedent at any time on the phone? Is it enough to say, well, they're in a 4-month relationship, so obviously, people who are in a relationship communicate by phone, but as PDS counsel noted, we don't even know that Ms. White had a phone, so.
Right, well, no, I think that's an extremely problematic argument that the government makes, is that this was a domestic violence situation. And so, that it was actually, I think Judge Smith, improperly limited the warrant to March 1st and should have gone back to January. I think that's extremely problematic for, I think, an obvious reason that somebody could be in a relationship for 20 years or more. And to open it up a search to the entirety of the relationship, really, there would have to be, I guess, I don't want to start, just, throwing out, well, what if and what if, but in this particular case, there wasn't anything in the affidavit about their relationship. And so, I think that is why that this search should have been limited to March 31st to April 5th. And then with regard to particularity, the language was overbroad with the any and all evidence. This was very short. Let's see, I'm pulling it up. the attachment B was extremely brief. And just, the handwritten, March 1st, 2018 to April 5th, sheets. And then any and all evidence, I think, regarding to the relationship between Tamia White and Robert Dean, it's extremely problematic. I mean, what does that mean? Any and all evidence? That, opens up this search to basically every single application, I suppose, could have evidence of some relationship. And I had stated in my reply brief that this warrant was more similar to the Abney warrant. I didn't go to into details, but if you do look at that at the Abney warrant, it was very much more restricted to time. It was June 8th to June 9th, 2018, and it was stated, in point A, point C, point D, point E, that the date was reinforced specific to the item that they were searching. This was just extremely broad categories of any and all evidence, information relating to the possession of a screwdriver. Did that mean that they could search all the photographs? I mean, there was nothing in the affidavit establishing probable cause to search the photographs or the music applications, and that's what the problem is here with allowing an affidavit to be so broad, is that it draws in things that are completely, unrelated and personal to the defendant. I mean, could they search? I think one of the cases, it refers to the Solitaire app. There's also apps, I guess, requesting an electric scooter, an electric bike. This language is drawing in I think and it would be helpful to look at the Celebrate extraction report and see how much information that is drawn in here. And then I just want to turn to, unless there's questions about this.
I don't have questions about those, but the government makes an argument, one about severability and two about harm. And I was wondering if you could address both of those arguments.
Right. Well, regarding harm, their argument is that the witnesses testified about the text messages, but really, Mr. Morris just testified about, I think, a couple of the communications. And when Mr. Morris,
I was focused on it for a second. It was undisputed at trial that your client stabbed the decedent. So if there was, I assume that your claim of harmless error is focused on the defense at trial, which was self-defense. And so the question would be, is that right? So that you, to the extent you think there was harm arising out of the admission of this evidence, it was focused on the possibility that a jury that was not exposed to this evidence would have acquitted on a self-defense theory as opposed to any other defense. Is that correct?
yes.
Okay. I just wanted to make sure we were focused only really on what did this add relative to self-defense, to the defense of self-defense, or how did it undermine the defense of self-defense?
Right. So I think Mr. Morris's testimony, he was clear, he said, Mr. Dean texted him, I think I'm going to jail. And he said at that point that he wasn't concerned that anything had occurred, and that it could be an expression or a joke. That was the testimony that the jury would have been left with. Instead, they were left with.
But the jury hears the timeline, right? Like that text comes before the encounter between Mr. Dean, right? Am I correct? Like there's that, I think I'm going to jail, and then then we have the timeline with White driving to McDonald's and collapsing there. And then subsequent, Mr. Dean tells McNeil and Lewis that he killed her and that he hopes that she's dead. And then recounts the fight between them and admits that he hit her first. I think, is that right? And that he hit her with the screwdriver, he says about 30 times, and then he threw the screwdriver away. And And then he leaves and comes back to McNeil and Lewis's apartment and is apparently calling around to see if she's dead. And then, the next day you've got Morris calling 911 to report the homicide, and showing his texts, which I guess that they do come into evidence, right? I mean, so, if we're trying to figure out sort of what the harm was from seeing the same information, I guess, from Mr. Dean's phone. And then what else? I mean, there's some web browser history of sort of trying to figure out what the news coverage is afterwards. If you've already admitted I was involved in this crime, I'm not sure how incriminating that is. What else is there that you think is very harmful to the self-defense claim?
Well, I think, going back to, taking us back to March 19th and messages with Ms. White and repeated calls to Ms. White, and it makes it seem more that it adds to an impression that the jury could draw that there was some history of domestic violence here. When in fact, the evidence of trial was more that, Ms. White was the violent one. And so I think that's, you send it back to the jury and they have this spreadsheet to peruse, and they see, this history of Mr. Dean calling Ms. White and arguments that really should have been outside of the warrant. It's very prejudicial to a self-defense claim, that in particular, I believe. And then I don't think there's any reason to be searching his IRS refund or anything like that. There was nothing in the affidavit setting forth that. But I think, drawing the warrant back to the March 19th, that really could have swayed the jury to think that there was some domestic violence history here.
With respect to the stuff that was after, I mean, the defense closing, the gist of it was really anything that the stuff that is reflected in the exhibit, the communications or information taken from the cell phone reflected in the exhibit after the stabbing isn't really incriminating. All of it is, if you stab somebody, it's all the kind of stuff you would do, whether you did it in self-defense or anything else. You'd be very upset. You'd be checking to see if the person survived or all that. So really none of that is incriminating. That was the kind of the defense closing, or a component of it. So, but I take your point that there's some information that is prior to that could suggest maybe ill will or anger, like I want to be back in the house. I'm mad at you. You're not letting me back in the house. So I see that line of thought. The prosecutor's rebuttal closing, the gist of it was roughly, here are 17 reasons why it's self-defense, why it's not self-defense. And a number of those were all, in all of the versions, including the version that your client gave to the police, there just isn't, he didn't say self-defense. He never said self-defense. Even here, it doesn't say self-defense, but moreover, some of it is disputed testimony. I understand there was an effort to impeach some of the government witnesses with bias out of desire to get rewards and the like. But even the statements made to the police, he doesn't say self-defense. And so the question is, not so much did any of this information, was it relevant and unhelpful to the defense? I think some of it was relevant to self-defense and unhelpful to the defense. So that far I'm with you. The question I think remains though, was the other kind of undisputed, evidence so contrary to self-defense that the marginal contribution of this would not have made a difference, and that it's so clear that's true that we should be affirming on a harmless error standard under, beyond a reasonable doubt. That to me is the harder question. So could you say, why do you think, to what extent do you think the government's evidence of self-defense wasn't otherwise overwhelming? And, what did you think the weaknesses were in it, or why you think that leaving aside this evidence, the jury might well have had at least some prospect of acquitting on that theory?
Well, I think there was strong evidence of self-defense from Mr. Morris and Ms. McNeil and Mr. Lewis. That, I think Mr. Dean was interviewed in the hospital after being shot. Mr. Morris was and Mr. Morris was I think received these text messages and everything on the night of the incident. And Mr. Morris, was there on the night of the incident. And he was able to testify that Mr. Dean said that I think Ms. White hit him first, and that he had a bleeding face and looked like, I think he had been scratched by keys, or that might have been Mr. Lewis that said that,
Am I right
right?
in recalling, one of the points the government made in rebuttal closing, was that your client in the statement to the police acknowledged that he had pushed the decedent first. Is that accurate description of what your client said to the police?
Yes. As I recall, but on the night of the incident, he had told all of the witnesses that she had attacked him first. And that he had, it makes sense because he had the scratch and the bleeding face. So where did that come from? It seemed like the screwdriver was a reaction to that. And so there would have been a stronger self-defense claim that he was actually attacked first. And that
And what
Ms.
was the
White was on
evidence that-
PCP and had the mental health issues that I think came into play. It could have, obviously PCP can produce sort of a state of schizophrenia, and there would have been stronger evidence for self-defense without these text messages.
Would you agree that the evidence indicated that your client's use of the screwdriver constituted deadly force? So that he would have been privileged to use deadly force in self-defense only if that was reasonably necessary based on whatever the decedent was doing to him?
Yes, if she was on PCP and she knows keys or something else even in her hand, we don't really know what she had. Attacking him, could have used deadly force to protect himself, right? I mean, they could have.
Was there any direct evidence that deadly force was used against him?
No, there wasn't strong evidence to that. There wasn't strong evidence to that issue. So that's my argument on that point. Of course, this is a difficult case with difficult facts, but I still, rest in the fact that these text messages prejudice him and weaken quite a bit the self-defense argument. And then I wanted to turn, because I see my time's up already, I wanted to turn to the prosecutor's procedure, because I really wanted to highlight in the transcript, really the problem with this procedure they use. And I understand about their resources, their limited resources, and how complicated this would be, but we have to look at the specific case. And in the October 5th transcript, starting on page 36, the judge asked, is this what you did, this general procedure? Is that how you did it in this particular case? And Mr. Gosso said, I believe so. That's how I do all of my extractions and have been kind of instructed to. I don't know if I have a specific memory of this particular case. And so, it would be, I think, a different thing if she could have come in and said, I went to this 14,000 page Celebrate report, and I went to call logs, SMS messages, and location data. She could only come in and say that they have this general practice, and she believes so, and everything like that. And she thumbs through it and she skims. That's just not enough. And then if you look at the 14,000 page report, there's a lot of different tabs, but it's pretty clear that, she could have come in and said that she limited her search to these particular tabs, but did she look at photos? Did she look at, it's just really not clear from the record what exactly she did. And so, for that alone, the prosecutor's procedure here was definitely inappropriate. And there should be more guidelines, and the prosecutors should be held to a stricter standard about how they, try to comply with the warrant.
I mean, it's awkward because it's the prosecutor doing the search, so we don't usually ask them to take the stand. But do you think that the prosecutor should have been asked to testify about her procedure? And do you think that it was defense counsel's obligation to say she needs to take the stand to say what she does and doesn't remember? This proffer isn't enough. Or was it on the government, who had the burden to show the legitimacy of the search, to put her on the stand to develop any evidence if there was anything more to be had?
I wouldn't say to put her on the stand, but I think this would, lends to there having to be a different procedure with a sort of a taint team, or they had this person to go through and make this comprehensive spreadsheet. for the jury, but they don't have somebody to go through and sort of pull, this SMS call log location history, something like that. So I don't know that it would be that burdensome on the government to be able to do something like that. And to have the prosecutor, to hold the prosecutor to have to come in and say specifically what she did in this case. You can certainly make notes and say what exactly I did in this case, which did I search? But and I think the defense attorney asked for more specifics, and then the judge clearly wanted more specifics. But that just didn't come. So
You can't provide specifics you don't remember, so that wouldn't have been feasible to provide more out of the prosecutor's memory. Obviously, you could have had more formal process by putting somebody under oath for sure, but I guess I am uncertain about an aspect of the question you were asked, which is, whose burden is it to establish that a search conducted pursuant to a search warrant was executed in an unreasonable manner? Do you know who bears the burden of proof on that topic?
I think that the government had the burden of proof there to provide enough information about what their procedure was. I don't think especially
That's your
right.
position, but are you aware of authority on that topic?
I don't have authority right now with me.
Yeah.
I'd have to look. And so I think since my time is up, I'm going to leave it at that because PDS did such a thorough, argument on the case law, and I definitely concur with everything they said about that. And then I've reserved 3 minutes for rebuttal. Thanks.
Thank you, Ms. Walton.
Let me be the first to say good afternoon, Your Honors.
Good
Michael McGovern
afternoon.
on behalf of Appellee of the United States. With counsel for amicus, there was a lot of discussion about whether or not this particular warrant satisfies the strictures of Burns, or what perhaps any warrant could in an digital context look like to satisfy the strictures of Burns. But as in Abney and In Re JFS, this court need not reach this issue to affirm this case. Rather, under the state of the law at the time the warrant was issued here, the official conducting the search of Mr. Dean's cell phone could reasonably have relied on the judge's decision to issue the warrant.
Why?
And
I mean, if you look at attachment B and it says you can search any and all evidence related to the murder of Tamia White. And I don't see how that's different from the warrant in Burns, right? Where it says you can look at any and all evidence having to do with this homicide. It's the same thing.
Well, in both Abney and in Re JFS, you had the same thing, a categorical expression that you can
had
search.
more
any and-
detail. I mean, I haven't gone back and sort of run the affidavits next to each other, but this is super broad. I mean, and so the good faith, I guess, has to be a pretty specific factual determination. I'm looking at this attachment. I don't see that many differences between the attachment that we looked at in Burns, right? I mean, again, any and all evidence related to the murder, any and all evidence related to the relationship between these two people, right? Any and all evidence related to his location, any information related to the suspect's possession of the screwdriver. Like, why on earth did we think that there was going to be evidence of the screwdriver on the phone? Where is that in the affidavit? I mean, it just is like sort of a wish list of, well, we'd like to find this evidence, so we're going to put this attachment together. And it's really broad. And so I don't, in Burns, we did say these principles are not new.
Well,
And they're not specific to suspects.
with respect,
We have to be vigilant. Riley tells us we have to be vigilant about cell phones, and I don't see vigilance here. I mean, this seems really, really broad brush.
So-
Would you like to comment?
yes, Your Honor. I think it's important in Burns to recognize that There they were dealing with a similar statement of any and all evidence that relates to a murder. And at that time, and we're talking here in good faith realm. At that time, the government made the argument, this is permissible under the law. And Burns distinguished the cases the government was relying on there. And those decisions were the Bass case and the Bishop case. And what Burns said is that in Bass and Bishop, what you had was an affidavit which established probable cause for a range of relevant evidence without a way of knowing in advance precisely where within that data the evidence would be found. And that phrase, range of evidence, is the same phrase that in the good faith analysis that Abney conducts, it says distinguishes the warranted issue in Abney with the warranted issue in Burns. And the differences that are pointed out in the warrant in Abney are that here we have a warrant which establishes probable cause to believe that the owner of this cell phone is the person who committed that murder. And we have statements from law enforcement that there is, from their training and experience, reason to believe that certain broad categories of evidence will be found on this phone.
Okay, but on the first point, we said in Burns, it's not enough for police to show that there's probable cause to arrest the owner or the user of the cell phone. Right? Or even to establish probable cause to believe the phone contains some evidence of crime, right? To be compliant with the Fourth Amendment, the warrant must specify the particular items of evidence to be searched for and seized from the phone and be strictly limited to the time period and information or other data for which probable cause has been properly established through the facts and circumstances set forth under oath and the warrant supporting affidavit. Vigilance in enforcing the probable cause and particularity requirements is thus essential to the protection of the vital privacy interests inherent in virtually every modern cell phone and to the achievement of the meaningful constraints contemplated in Riley. So sorry for the read aloud, but that's what we said in Burns. And to the point that, you have probable cause from this officer. I mean, the officer starts out by saying, well, I think based on my experience, I know that people who commit crime in DC often use their cell phones in ways that reveal their location and or activities before, after, or while engaging in criminal activity. Now, I could abridge that statement and say, based on my experience, I know that people in Washington, DC often use their cell phones in ways that reveal their location and or activities. The people who commit crime is a subset of all of the people. And I don't see how that's limiting at all, right? I mean, that's everybody, everyone who has a phone, which is the point of Riley. I'm just not seeing where in the affidavit or in the attachment that there is the particularity or the probable cause that you needed for the vast swath of data that you got in the Celebrate report that the prosecutor looked for. And so I'm really struggling to see good faith here.
So let me first address where I think you can find the particularity from a good faith perspective, and then let me address where I think you can find the probable cause from a good faith perspective. That is, in Abney and in Ray JFS, they recognized that at the time that this warrant was issued, which is pre-Burns, a reasonable officer could find that a statement searching for records of evidence of a crime, a particular crime, was particular enough to satisfy the particularity requirement. Then we turn to, in addition to that, and Your Honor, I understand your concerns that that's incredibly broad, but in addition to that, you do have more here. Your Honor, you have categories.
If that's what Abney says, I don't see how it's consistent with Burns. And that's a problem because Burns predates Abney. So Burns has a good faith discussion and says, this warrant, there is not probable cause, there is not sufficient particularity, there is not good faith. And I don't see, if that's what Abney, if you're representing that Abney says, then I don't see how it's consistent with Burns, and Abney cannot overrule Burns.
Well, Your Honor, let me first turn to Burns and its good faith argument. And I would note that particularly what Burns focuses on in their good faith argument is the probable cause issues with the Burns warrant. What they say is that there was no effort to tailor the scope of the facts of the case to the slender showings of probable cause made in the affidavit. And specifically point out that they were requesting categories of information, specifically requesting categories of information for which a detective had acknowledged they did not have any information that there would be that data on their phone. And then go on to point out that there was no allegation in the Burns warrant, and this is the section that was discussed with PDS's attorney, that the detective's knowledge at the time he submitted that Mr. Burns was not a suspect. And so Abney reads Burns and says, this is a different warrant, so we need to look at this warrant. And the warrant in front of us does contain probable cause that the subject whose phone is being reviewed is, there is probable cause to believe they are the person who committed this crime. Additionally, there are allegations that there is reason to believe there are multiple categories, and the way they actually phrase it is a range of relevant evidence on that phone. And where you have showings of probable cause that someone is the person committing the crime and statements that show probable cause to believe that the phone would have a range of relevant evidence as to that crime, under the law, prior to Burns' very specific articulation of how particularity should work in warrants moving forward. Prior to that, there would be good faith to rely upon
You
those.
lost me. You're
those
saying that
showings.
this isn't what you're saying is in Burns? I'm a little confused about where we are. Are you talking about Abney? Are you talking about JFS? Or are you talking about
How
Burns?
Abney reads Burns.
How Abney reads Burns?
How Abney
Right,
reads.
but I thought you were
Burns.
taking me back to Burns. So-
I did previously.
Okay,
In Burns, when it was discussing particularity, it discussed the cases the government relied upon and distinguished them by saying, in all of those cases, there had been reason to believe that
Right,
there
that-
was, and this
that
was the
wasn't in the
exact.
good faith discussion, though. Right? I mean, I guess I'm lost. If you would like to point me to where you were talking about in Burns about good faith. But the distinction of Bishop and Bass
My
is
point about
not-
good faith
is
in
not in
Burns.
good faith.
I apologize if I've confused you, Your Honor.
Okay,
My point about good faith in Burns is that Burns' good faith relied specifically on the lack of probable cause, tying the majority of this phone to any evidence as to the murder because, and at this point in Burns, and this is at page 779 of Burns, they recognize that the detective didn't know that this individual was a suspect. So there is a tying of the good faith analysis to the fact that the warrant in Burns doesn't involve an individual who's known as a suspect at that time. And in fact, the warrant in Burns permits categorically the examination of data for which a detective has testified he did not have reason to believe there would be evidence of on the phone.
Can I ask you, I mean, I take that point, and I think it is, that discussion is in a paragraph that begins with, there's more in the record that precludes application of the good faith exception, and then refer to, among other things, the detective's knowledge that Mr. Burns was not a suspect. So it's there as part of good faith, but it is, at least it seems to me, on page 779, but it is true that that paragraph follows a preceding analysis, which says, this was a bare bones warrant. I'm paraphrasing, but the preceding analysis is this was a bare bones warrant. And the sentence immediately preceding the one you're relying on says, given that this is bare bones or less in this case, we conclude on this ground alone that the good faith exception provides the government no refuge. And so I guess the question would be, if the warrant in this case is equally bare bones to the warrant in, or as the warrant in Burns, then does that, and maybe if the same was true in Abney, was Abney inconsistent with Burns? And if the same was true in JFS, was that inconsistent with Burns? But I mean, what do you make of the fact that it seems as though Burns said on the good faith part of it, before we even get to the suspect and other problems you were identifying a minute ago, this is just bare bones, so bare bones that nobody could rely on it, leaving aside all those problems. And how do you fit that piece of Burns in with Abney, JFS in this case?
What I would say, Your Honor, is that this absolutely is not the type of bare bones affidavit that was at issue in Burns. The affidavit in Burns didn't have what we have here, categories C through J specifically listing what types of evidence that, based on the factual statements that had been made in the affidavit, which is incorporated in the warrant, there is a reasonable probability, again, not a more likely than not standard, but a reasonable probability, lower standard, that this type of evidence would be on that phone. And for each of these categories, there are specific facts in the warrants that go to each of them. So there are the first, C, any and all evidence regarding the relationship between Tamia White and Robert Dean. There are statements in the warrant affidavit, which makes clear that this murder arose between individuals involved in a domestic relationship and arose about.
Maybe so, but why is there evidence on the phone of that? And why is there evidence of the crime on that? We don't even know if she had a phone.
Well, Your Honor, even dating back to Gates, the courts have recognized that you can use common sense when establishing probable cause. And so it's not.
Maybe you can use common sense, but don't you have to sort of spell it out and say, there's a 4-month relationship here. There, we think that there is evidence, we are aware that this relationship was contentious. We think that they, had fights before that may have been, communicated on the phone. We think she has a phone, so they communicated with each other. Or, there is nothing to indicate that their relationship is going to be documented on the phone. It's just not, they didn't say anything about it.
So I agree that if the warrant had said all of those things, there certainly would be more than probable cause to believe that there were to be evidence of those communications on the phone. But the failure of it to have all of that Your Honor just identified doesn't defeat probable cause. And I would point, Your Honor, to the paragraph.
Okay, sorry, go ahead and point me to the paragraph.
To paragraph 10 of the affidavit, which spells out that the defendant had confessed to witness 2 that he was angry at the decedent because she blew through his social security check in 2 days, kicked him out of their apartment, that he had been living in a communal laundry room, and that she would not answer the door for him. So it's apparent from the face of this warrant that there are communication attempts that he is trying to make with the decedent, that their relationship was undergoing strain. There's also a statement in paragraph 14.
Nothing about phone communications, and this just talks about, them having a relationship or, having some sort of dispute for 2 days, and this warrant is for 6 weeks.
And Your Honor, I believe that the idea that they spoke on the phone, that there would be evidence of their communications on the phone, is a common sense conclusion, given that he is communicating with them, and there is evidence or there are statements in the affidavit
that missing each other, which is my understanding is the government, a police officer thinks they've got probable cause to search the phone, has to draft the affidavit and give it to a judge to review and say, this is why we think we can search the phone. And they have to spell it out because they're not expecting the judge to be adding in information to justify why the government gets to search the phone. The judge is supposed to be the neutral arbiter, right? So if you're saying, oh, well, it's just common sense to fill in all of these gaps, the judge is supposed to be looking at the warrant and looking for the gaps and saying, wait a second, I don't see it. And then the detective can go back and augment it if there's other stuff to put in there. But I don't understand this idea that you just have a cache of kind of common sense floating out in the ether that you don't have to memorialize in an affidavit setting forth probable cause.
The Supreme Court in Illinois v. Gates said, quote, probable cause may rest on common sense conclusions about human behavior.
Right, but were they talking about common sense kind of out there in the ether, or were they talking about common sense that is explained in the affidavit?
I believe, Bo, that they're talking about common sense, but I also do believe it is explained here in the affidavit. I think if you turn to paragraph 30, the law enforcement officer says, based on my experience, I know that people who commit crime in Washington, DC often use their cell phones in ways that reveal their location and or activities before, after, or while engaging in criminal activity. It also states, and this is the final sentence of paragraph 30, I know that from call logs, text messages, emails, and any app enabling communication with others frequently include communications that shed light on a cell user's relationship with others and its tenor at any particular time. For example, in the case described above, the decedent and her family. And the
Can I
relevance
ask you,
of,
I mean, this question of, leave aside for a minute how much it has to be explained in a warrant, the line of thinking, but an aspect of the probable cause issue that's under discussion is if we know the defendant has a cell phone and the defendant is charged with committing an offense against a friend or someone with whom there's been a romantic relationship. We have no direct evidence about whether the victim of the offense has a phone. Is it common sense to that could support the authorization of a search warrant focused on this idea, at least, leave aside particularity for a moment, but imagine a warrant said only the following is, I want to search the defendant's phone because the defendant is charged with, and there's probable cause to believe the defendant committed an offense in which he committed a violent crime against someone with whom the defendant was in a domestic relationship. The defendant has a cell phone. We don't have any evidence about whether the decedent has a cell phone. It'll say it's a homicide. The decedent has a cell phone, but it's common sense, Your Honor. So issue a warrant allowing us to look through the defendant's phone for all communications with the decedent. And there's probable cause to believe there because it's just common sense. Adult people have cell phones. That's actually a legal question. And I believe there's actually law on it around the country. Are you aware of authority about whether that is a sufficiently common sense inference to allow the issuance of a warrant that rests on that idea, or whether that's really just too speculative because some adults have cell phones and some don't?
Your Honor, as I stand here today, I'm not familiar with, if you say there are cases that
My
are.
this is
that
recollection.
issue.
My recollection is somewhat unhelpfully or unsurprisingly, courts don't all take exactly the same view about it, but there is some authority on that question that's a little divided.
Well, what I will say is one of the cases that is cited in Abney, in its good faith analysis, because again, Abney doesn't address, as we're asking you not to address, or not asking, I apologize, as we're indicating, it doesn't need to address whether or not this fully satisfies Burns, because the question that can govern this case is whether or not the government would rely in good faith on the warrant that was issued. But in one of the cases from Maryland they discussed, what they made clear is that the determination of whether a particular cell phone can be searched where there's of a suspect, where there's probable cause to believe that they have committed a crime, will depend upon the facts of the case and then very fact-specific inquiry as to whether there should be reason to believe that there would be evidence on
Right.
that.
So we can't just say, well, in Abney and JFS, they found good faith there. So we have to find good faith here because we have to look at the facts.
So, and
Of
here,
this
so
warrant that's
looking at these
attached to it.
facts, Your Honor.
And maybe compare it to Burns, where we said, no good faith.
So we would look at the facts of this warrant and we would compare it, I think you would compare it both to the warrants in Burns and to the warrants in Abney and JFS to see.
Maybe the Warren and Burns first, right? Because to the extent that we think that there's some distance between Abney and JFS and Burns, we'd want to stick with Burns first because that's.
Well, I would think
controlling
that since
authority.
both JFS and Abney cited to Burns and decided that they were consistent with it, that you would need, this panel would need to apply those decisions as well as they are just also decisions that predate whatever decision comes down in this case. And they do.
That's actually a really interesting and complex question about like precedent, unprecedented, and if decision A says one thing and division B says, well, this is how we interpret division A, and then the court in division C says, well, actually, I don't agree with B about what A meant. What the division, like what stare decisis tells division C to do is, I don't think it's well settled in our case law or very clearly settled around the country how you respond in that setting. Some courts take the view that I actually wrote about this in a concurrence some years ago, but some courts take the view that Division C should follow what B said about A, unless what B said about A is kind of beyond the reasonable interpretation of A, rather than what C might have originally thought A meant. But that's very murky about exactly what should happen. To me, to my knowledge.
Understood. And Your Honor, none of that has been briefed, so I apologize for bringing up perhaps a very sticky issue. But what I'd like to say is that I think there are significant differences between the warrant that is at issue here and the one that is at issue in Burns. And in
I just wanted to, and that may be so, and you know, we certainly will take a close look at that, but I did want to just pin down, because there was a footnote in your brief, not written by you, but by your colleague, saying that the government reserves the right to challenge Burns. And so I've just wanted a little bit of clarity on that, because my understanding is that the government did try to challenge Burns, tried to go en banc, and that was denied. So
Yes.
I just would like a little clarity about what the government thinks the status of Burns is.
Your Honor, with respect to this appeal, as I stand here today and I'm asking you to affirm, I'm doing nothing more than asking you to apply Burns as it is written. But I am asking you to apply Burns as it has been interpreted by both Abney and In Re JFS in terms of how the good faith analysis differs, but depending upon the warrant that is at issue in the case. Where Burns was a bare bones warrant, which established only, it didn't establish only that there was probable cause to believe that there was a text message between an individual who was not identified as the suspect who was related to the murder to the person who was murdered prior to his being murdered, that would be found on the phone. And then in the attachment B, that was the probable cause. And then in attachment B said, we should be able to look for all evidence of the murder whatsoever, and we should be able to look in internet search history and photographs and areas where a detective specifically testified. At the time we sought the warrant, we did not have probable cause to believe that evidence would be found in those areas. That warrant, this court found, lacked good faith. The detective could not rely in good faith on the issuance of that warrant in order to save the suppression at issue. Now we turn to In Re JFS and Abney, and we look at the warrants in those cases, and both of them attach significance to the fact that there is a suspect warrant, that the person at issue here is the suspect, and that there is probable cause to believe that they committed this crime, and that based on law enforcement statements within the affidavit, there is reason to believe that people use their phone in any manner of ways that would provide evidence that would support.
Let me ask you to clarify. I understood at one point you to be saying that generalized knowledge that was stated in paragraph 30, which you cited, that looks kind of boilerplate to me, that wasn't enough on its own, or that there needed to be some other particularized facts too. Is that a misunderstanding of your position? Would paragraph 30 of the warrant be enough in a suspect warrant on its own, is what you're now saying?
You're asking, I think it's difficult for me to conceptualize what type of warrant we're talking about, and I think that's why the issues are very fact specific and driven. I think the fact that the warrant in paragraph 30 states that oftentimes people use their phones in ways that reveal their relationship with others gets additional relevance from the prior factual statements in the warrant affidavit, which go directly to the fact that this particular crime arose in a domestic violence situation where the relationship with others matters. In a crime where that wasn't at issue, then the observation that people communicate with others could reveal the nature of their relationship at any given time might not matter at all and might not give you a foothold into probable cause or to search the phone.
So it sounds like it works in tandem with things. Let me draw you to paragraph 31. Speaking of relationships with others, did I miss something in the record, or it seemed to me that there was nothing that was challenged here, that there was a belief that Dean carried it out any other way except for by himself. Is that correct?
The murder, yes, that there was no person present that facilitated the murder at that time.
So should we look at things like this and accord even less weight to certain paragraphs when it looks like there's kind of a boilerplate paragraph there in 31 that's not necessarily even relevant here? Can we like fully say that paragraph 30 and others are really things based on their experience that apply to this, or something that we just put on warrants to try to get them?
Well, Your Honor, I think you can look back to Burns, which if you see paragraph 31 as simply evidence that this is a boilerplate warrant, then the question is that acceptable? And Burns says it's absolutely fine to start from a place of boilerplate. There's no problem with using a boilerplate to draft your warrants if you're including the particularized information. And so the leaving in of information that may not be applicable, I don't think shows any sort of bad faith or defeats the probable cause that otherwise exists within the rest of the warrant. But with respect specifically to the facts of this case, I don't think we can go so far as to say it was necessarily left in as a mistake. There was evidence that this individual, that the appellant had contacted someone to pick him up. And when he picked him up, he told him about what had happened and that they then drove around for a while. And
That's Mr. Morris, who goes to the police the next day and says, or calls 911 and then turns his friend in. The government thinks he's an accomplice?
I didn't mean to state that his specific actions necessarily made him accomplice, but at the time, I don't know that the government had information
The
as to
government
how.
had all of this information. That's how they got the warrant. They talked to Mr. Morris. Mr. Morris called them, right?
But they also knew.
Called 911 and then spoke to the police and showed them her phone, like that. The government thinks that, so this accomplice paragraph is about Mr. Morris.
I think this accomplice paragraph not only could cover the communications he had with Mr. Morris, but also could cover anyone who harbored him for the period of time before he was arrested, that it's reasonable to believe he didn't have a place to stay. He was no longer able to stay at the decedent's residence. He needed somewhere to stay, and he may be communicating with others in order to obtain that. And in an investigative context, I don't think that it would necessarily be inappropriate for them to have included a paragraph referring to potential accomplices. When they recognize that he has asked others.
That's on the phone too, right? I mean, this seems completely speculative to me that he has accomplices, that he's communicating or has data on his phone about. But I take the government's
Speculative,
argument.
which was shown right when it showed that he was searching places
Doesn't
to
make it less
stay.
speculative ex ante though, right? We don't look at what you
It
found
may-
afterwards to justify the warrant, do we?
But the ex post, as well as the experience in general, can show that it was a reasonable inference that was being made. And the question is this a reasonable inference to draw about what can be on the phone? Those reasonable inferences are the common sense conclusions that can be a part of a probable cause determination.
Does the government want to turn to the extraction argument? I mean, unless my colleagues have anything else to ask about particularity and probable cause.
Yes, Your Honor. So what I will point out is the extraction issue here. First of all, there is not, the motion to suppress did not seek to suppress any data that was not specifically within what we assert are the particularized categories. And again, I'll refer Your Honor to categories C through J of the warrant.
So you're saying even though there was data that was turned over, like web searches, that there's nothing in the warrant about those, there's no challenge to that? Is that what you're?
Well, internet search inquiries are included in the affidavit in the section on training and experience that people use their phones. So
But it's not an attachment B, right? I mean,
it
despite
is
the
all
breadth-
records.
Despite, I mean, unless you say it falls under any and all evidence related to the murder of Tamia White. Which encompasses, I think, everything that follows after A. So arguably that does include.
Well, the internet searches relate to his location. The searches that he was specifically doing were for the homeless shelter at which he went to.
Well, that's one of them, but.
That's one of them.
There are others that
Correct.
don't
And
seem
there,
related in that way.
I'm sorry, Your Honor?
There were others that don't seem related in that way. Some of them were like updates about what the status was of whether the decedent had passed away.
Correct. And I think that does go to his activities afterwards that he is checking up on.
They're not, I
whether-
mean, to the extent you had said as the intro to this discussion that everything that was admitted into evidence fell within 1E to J of attachment B. I'm not quite sure I'm seeing how everything fits into E through J.
I'm sorry, everything fits into attachment B of the warrant.
I mean, I guess this is taking us back to particularity, sorry, but if we think that actually you need to specify, we can look at SMS messages because we have probable cause to think that he was, texting with people. We can look at photographs because we have probable cause to think that he was taking photographs. Don't you think we need some sort of specific, we can look at internet searches? I mean, in that respect, Burns, the warrant was superior to this one because Burns actually said, I believe, maybe I'm mistaken in my memory, it said, we want to look at web history, but or at least that is what happened, and that's what happened here. And I don't see any specific, I mean, you have topical categories of we're interested in this kind of information, but it doesn't tell you what cache of data on the phone you can look at, right? And arguably looking at web searches is very different than looking at SMS information.
Well, so again, I think the warrant incorporates the affidavit. The affidavit states the types of evidence of commission of the crime that users use their phone
But you think
for
you don't
or web
need,
searches.
you don't need sort of the types of data. The words are not helping me here to be more specific, but you think it's enough to have topics of information versus saying we can look at this particular application on the phone.
Well, I think at the
Photographs
time,
versus texts versus email versus whatever.
so back to particularity, because I think
Right.
this is what we're actually discussing.
I warned you, I was
I-
getting you back there, sorry.
What I will say is at the time that this warrant is being issued, there's no way to know, because there's been no analysis done on the phone, what apps, what type of data
Right, but
are on
Burns-
that phone. Like,
Burns does suggest that this is the kind of inquiry that you need to I mean,
But
that sort
how-
of particularity is required, right? Because Burns says,
Burns certainly indicates that there needs to be a date range, but Burns also recognizes.
not just
and-
date range, but types of data.
But one can only describe types of data to the level of specificity that's available to investigators at the time the warrant is sought.
Precisely.
Precisely. And at this
That's-
time,
That's why
at
you
this
get the warrant.
time,
Yes.
at this time, investigators did not know if there was an SMS texting, if there was
Right,
a
so maybe
WhatsApp.
so maybe they don't have probable cause for it at this time.
But they know that these apps exist and that people use their phones to communicate, and they know that he has at least been able to
But
text,
why doesn't
communicate.
that argument just prove too much, right? Like, people have apps on their phone, so maybe those apps on their phone have some evidence of the crime that we suspect this person of committing, and this is their phone.
Because the level with which the description needs to be placed into particularity must allow for investigation, reasonable investigation. And so.
I'm just having trouble distinguishing between reasonable investigation and rummaging.
Well, there's no indication that there was a rummaging that occurred here, Your Honor. So certainly, based on attachment B, there was a very specific search done for the types of information that were being sought, which were communications, photographs, web searches, things of that nature, all of which there was probable cause in the warrant.
So now
I
we're
believe
getting back,
existed.
I guess, to execution, and I'm not sure that we have specific information. I mean, the AUSA who looked at this 14,000 page extraction, the PDF didn't really remember what she did.
Well,
sort of said, well, I kind of looked around and yes, I agree that, you know, texts in a date range that is authorized can be right next to texts that are not authorized, and you kind of see it and, you know, I pick out what's relevant, is what she said.
so there's one important piece I think is missing from both our particularity discussion from the warrant as a first issue. And then I'd like to turn to, you mentioned the representations of the AUSA, how specific they may or may not have been, and also what would have been feasible. I think what's really important here was there is no challenge below to anything other than the provision of the full report to the government. That the actual process by which the AUSA reviewed it was not challenged in any way meaningfully below. And that was noted by the court in their decision that there was, and I apologize, I actually jumped. I said that I was going to go back to the warrant, but I ended up speaking about, but I'll continue to speak about. There was no challenge to the specific steps that the AUSA took. What they said is it doesn't matter what she did because the offense was in providing the entirety of the report ever. So that's really the challenge that is before this court. And the question is whether or not the trial court erred in finding that that step was reasonable, given the information the trial court had before it at that time.
Do you have a view of whose burden, to the extent there
Yes.
facts about any of that, whose burden it would be to establish them?
Yes, Your Honor, I point you to the Christie case from the 10th Circuit that we cite in our brief. And that's a case that was written by then Judge Gorsuch. And it's clear that there is a burden on the defendant to show that the search was unreasonable in scope, be outside of the warrant. In our briefing before the trial court here, we also cited to a case Reyes Castro that comes out of Georgia, which is a Georgia state case. And that similarly places a burden on the defendant to show the unreasonableness.
I'm sorry, can we just go back to, you said the defense's argument was only that the report never should have been given to the prosecutor? Is that what you're saying?
Yes, Your Honor.
But the defense also says, look, we need to have some sort of taint team. Essentially, the defense is arguing like, she shouldn't be doing this, right?
Right.
Like, so I
So-
guess I'm just not sure what's the ultimate point of your.
So the
argument
court,
with
in
the litigation.
recognizing that the challenge is to the provision of the full report, pre-search before anyone's looked at it, that the provision of that entire report offends the Fourth Amendment. And the court asks, I'm trying to understand your argument, what alternative is available? And the only one that is presented by the defense below, so the only one that's really discussed in the record, on this particular record, is they say there should be a taint team, someone from the United States Attorney's Office who goes through and redacts all of the information. Now, I think it's curious to ask, what does that do for Fourth Amendment protection? You still have a government actor within the government house that has to peruse the warrants in order to get, or sorry, the entirety of the report to get to those sections that may contain the information that they think attachment B might have.
Point, not usually the government's point with respect to taint teams. You sound a little bit more like a defense attorney when you raise that concern.
And I think, Your Honor, I say that because there's a difference between, in the context of attorney-client privilege, what's at issue there is protecting the content of the communication, right? There's an evidentiary privilege that's protected by taint teams in the attorney-client privilege issue. None of this has been briefed, so I don't want to go too far afield, but I think there are relevant considerations that differ between when a taint team is appropriately used and can protect certain types of privacy interests versus.
You're making a very nuanced issue preservation point. I want to make sure I understand, as Judge Easterly has been trying to do. I'm trying to make sure I understand it. I understand your point that the challenge was focused on, at least eventually, on the physical making available of a 14,000 page document directly to the trial prosecutor. That's their argument. That's at least the focus of it. And is your point that if assume for a moment there's nothing intrinsically wrong, nothing unreasonable about that, and there might have been a way for the prosecutor to have done that, handled the document in a very careful way to have not created additional problems, then, that's only, the question of whether it's just fundamentally flawed to hand it to the prosecutor, however the prosecutor handles it, that's one legal issue. If the issue instead is once the prosecutor had it, did the prosecutor use it carefully or carelessly and unnecessarily expose herself to material that shouldn't have been? Is your point that's a different issue that wasn't raised, and so that it was kind of wasting everybody's time to get into the question of asking the prosecutor, what did you do with it? That was just not germane to any point anybody was making, because it does seem like implicitly that must have also been a part of the dispute. Otherwise, why was anybody talking about, why was the prosecutor proffering about how she handled a document if there was no legal issue relating to whether that was a reasonable or unreasonable way to handle the document? And the only issue was it should never have been handed to her in the first place.
So I would need to re-review much more carefully the transcript and to see the precise setup of how the prosecutor came to start describing this issue and who it was raised by. But regardless of how it was raised, once it was raised, the defense still made very clear that they weren't taking issue with the process that was employed, and where they were focusing their efforts for their challenge was simply on the provision of the report in toto to the government prosecutor in the case. And so that question, which was presented to the trial court that was teed up, is the one that in that way, that's what the trial court interpreted its job to do in order to determine the issue, and found Rule 41 does specifically acknowledge that there is an in the ESI context, when we're talking about electronically stored information on computers and on cell phones, there is an overcollection issue. One must overcollect before and make a copy of before you actually implement the search. And I see that you have a question. I did want to point out one thing that I don't want to lose track of, which is that the search that was conducted here was entirely consistent with what was in the warrant as to how the search should be executed. And that's at paragraphs 33 to 35 of the affidavit, which explains some of the issues and how searches of ESI information like cell phones are an iterative process that might involve review of certain areas, scanning storage areas, or perusing briefly certain parts of the information that is obtained, just to make the preliminary determination of whether to dive deeper to see whether it is within attachment B.
So I just want to make sure I understand, right? Rule 41 says that you can seize electronic storage media, right? And then it authorizes a later review of the media consistent with the warrant. The seizure of the data is the seizure of the zeros and ones, right?
Mhm.
So then there's the translation by the Celebrate software into a PDF. Now, we can argue about whether or not that's a search of that data or not. The government represented at this hearing, it doesn't have the capability just to pick which ones and zeros. And so, this is going to be a moving target for years to come, because I'm sure the technology is going to improve, and we wouldn't want a court to say anything that sort of sets in stone what the government can or can't do. But at the time of this hearing, the government made that representation, and the defense said, okay, so you have to translate all of it. But then you turned it over to the prosecutor, who just looked through all of it. Now, granted, she says she just, mainly focused, she thinks she remembers, but she doesn't really know, because she doesn't really remember what she did in this case. Thinks that she looked at the table of contents and within the date range of the warrant. But I'm not sure how Rule 41 authorizes that. Rule 41 just blesses the seizure of the zeros and ones. It doesn't seem to speak to at all about what happens after that seizure.
it says that you may then review it. And when it says it means the data that you've collected.
Right, but
Now-
it doesn't specifically authorize this means of subsequent review. And so it doesn't, provide an answer to the question of whether for Fourth Amendment, and it couldn't answer the question of whether what the Fourth Amendment requires by way of a reasonable manner of those subsequent reviews.
But then we look at the facts of this case. So
But just so you agree with that so far, there's nothing in Rule 41 that says, oh yeah, and by the way, it's fine to put, here's something that's fine to do for Rule 41 purposes. Create a 14,000 page document that includes all the information, including stuff that's temporarily outside the scope of the search warrant, and then hand it to a prosecutor. Nothing in Rule 41 says that's reasonable.
that is not expressly within the
Right,
rule.
nor does the warrant itself authorize that. The language in Rule 41 just says subsequent review and, leaves to the Fourth Amendment and maybe other interpretations of Rule 41, but mostly to the Fourth Amendment, what reasonable modes of further review are. Agree or disagree?
Agreed.
And then with respect to the warrant, which, I mean, I know your position is warrants don't require language about search protocols.
Correct.
I take your view to be that where warrants have such language, if officers comply with that language and the language, whether correct or not correct, is close enough to correct that it could be relied upon in good faith, that then the good faith exception would protect an officer who relied upon that language in executing the warrant. I thought I understood your brief to say that.
Yes.
And maybe that would be true. That's all interesting analytically, but this warrant, it's not like this warrant expressly says, by the way, it's fine for Cellbrite to create a logical extraction and then create a 14,000 page document. And then it's fine to hand that to the prosecutor and have the prosecutor review it and pick out what is within the scope of the search warrant and introduce that into evidence. There's nothing anywhere near that specific that you could say means that an officer could rely upon this in good faith, officer slash prosecutor could rely on this in good faith as the manner of executing the warrant, or do you disagree?
I disagree.
Okay,
I believe you should look at paragraphs 33 to 35.
Which I have, but why don't you point me to the parts of it that you think support your disagreement?
Specifically in paragraph 35. So I think paragraph 34 sets forward why certain tools may or may not work in the context of searching data. And it says, and I'm pointing towards the middle of that paragraph. Indeed, the vast array of apps now available on cell phones can make it nearly impossible to determine the precise form and organization of user information and metadata prior to conducting a search. So the idea here is that there may not be a way, the warrant recognizes there may not be a way for us to specifically understand what categories are here until we go there.
I get all of that, but I guess, and maybe this is, it's complicated by the interaction between the dispute about which issues are properly in front of us. But if we're focused on the issue you say is in front of us, which is, was it lawful for DFS, which may or may not be the government for purposes of the Fourth Amendment, a disputed issue, I know, or at least at one point disputed, to hand this to the trial prosecutor to pick through herself? I just don't see anything if that's the legal issue, I don't see how we could say, well, I don't know what the answer to that legal issue is, but the warrant authorized this and the prosecutor relied on that in good faith. I just don't, the warrant doesn't answer that question, it seems to me. And so I don't see good faith as helping much myself yet, but I'm open to being persuaded, but I don't quite see how it adds anything because I just don't see, if that's the legal issue we're to decide, I don't see that the warrant speaks to it.
Well, so paragraph 35, I will say, recognizes that law enforcement officials or other analysts with appropriate expertise may need to conduct more extensive searches, such as scanning storage areas not obviously related to the evidence described in this warrant application, or perusing all stored information briefly to determine whether it falls within the scope of the warrant. MPD and its agents intend to use whatever data and analysis techniques appear necessary to locate and retrieve the evidence described in this warrant. So it recognizes that there must be the ability to at least scan or peruse a broader swath of
Understood.
information.
But if the issue is, you think the only issue that was being disputed was, that's all fine, but what the last thing you can't do is give it directly to the trial prosecutor to do that. That, I mean, if they're not disputing, yes, that needed to be done, but it needed to be done by somebody who wasn't the trial prosecutor. The
But-
warrant doesn't tell you the answer to that question.
But the Fourth Amendment case law doesn't tell you
I get that.
The answer
But that's
to
a
that
merit- but
question-
That's a merits answer. That's not a rely on the warrant's authorization question. It might be a good faith. It might be, if you think the good faith exception applies not only to modes of execution that are specified in the warrant and approved, but also to any mode of execution, even if not in the warrant, then the lack of case law would be relevant perhaps, but I'm not so sure that the manner of execution, if it's outside the scope of the warrant, is subject to the good faith exception. So I'm not sure that helps, but do we have to decide any of this? Because there's a last piece of the puzzle.
No,
Which is
Your Honor, you don't. There's
there's
harmless.
severability. Well, there's harmless error, but so I said last piece, there's a penultimate piece of the puzzle, which is severability. So there's a question about, let's say that the execution of the warrant in that respect, the challenge respect or other respects, maybe if two things are challenged, possibly handing it to the prosecutor and then how the prosecutor handled those things. There would be a question about whether what was done there was so flagrant as to warrant exclusion of things that would have been discovered under an appropriate, through an appropriate manner of execution of the warrant.
Correct.
So there's that topic. And then there's also harmlessness. I know I think it might be evening now, so.
So I will try to be brief on both and I welcome questions specifically.
And I should
here.
say, I'm complicit in it being evening, so I don't mean to criticize anybody. before
As
that.
we all are.
Yeah.
And I welcome your questions to further target my discussion of those issues. But what I will say is on the severability issue, there's no allegation here that there was any information looked at, let alone sought to be introduced at trial that fell outside the scope of the date range and the categories set forth in the warrant. And so there was nothing to suppress based on the execution of the warrant here, even had another individual simply redacted everything that didn't include anything but the text communications from the date range that are indicated in the warrant and the call logs from the date within the warrant and the search information within the warrant, which I understand we've had discussion about whether or not the warrant does include that, but.
And so that's your severability argument, am I correct? Or are you getting to harm, right? Because I mean, for severability, as we explained in Burns, you have to, we said that there's this 3-part test. We didn't officially adopt it. But we said that a severance is available only if there are valid portions of an otherwise invalid search warrant that describe with sufficient particularity items to be seized for which there's probable cause. There might be some debate about whether there's a description with sufficient particularity. Then you have to distinguish the particular items from the invalid portions. And then, and this was what we didn't totally embrace, say that the particular parts make up the greater part of the warrant, which I think if that did apply would be very difficult in this case.
I would disagree. Excuse me. I would disagree. I believe
I mean,
that the
maybe
particular.
with the output, but if you're just looking at the warrant ex ante and all of the things that are described, I mean, it says, we want anything related to the homicide.
But lays out again in all of the subparts of attachment B, very specific categories of that information, all of the evidence that was obtained here that was sought.
Can I ask you an antecedent legal question? Because there definitely is a discussion of that in Burns as it relates to severability of items recovered under a general warrant, where a more specific warrant might have authorized a tailored search. But and that's its own set of questions about what happens when you have a general warrant that's problematic. But if we're focused on a manner of execution, so sometimes the word severability is used. It's not entirely clear to me that the standards are the same. And some of them are not applicable. I mean, if you have a perfectly good warrant and then someone is alleged to have executed it in a way that exceeds the scope of the warrant, some of the discussion or criteria aren't really applicable. And the issue is more, if you had confined your manner of execution to what was lawful under the warrant, what would you have found? And if you found more, we'll suppress the more for sure. And in some cases, we'll suppress what you should have found if you had executed the warrant legitimately, and that seems to be kind of a flagrancy kind of analysis.
Correct. So I would point your honors to Porter, the DC case from 2012, which indicates that to suppress items that are seized, which do fall within the scope of a search warrant based on an improper execution, you have to show that there was a flagrant disregard for limitations on the authorized search. And so particularly given the language that we discussed in the warrant and the accepted unchallenged manner in which the prosecutor said they went about reviewing this information, there doesn't on this record show a flagrant disregard of proper execution of the warrant in order to try and locate the individual items of evidence that are listed in attachment B. And we deemed it severability. Perhaps that's why there was some, I don't know that they use the word severability in Porter, but I would point you to Porter as to what the standard is as to when you can suppress items based on an execution-based analysis. And then finally, on harmless error, I think you had a robust discussion with appellant's counsel about that. It is the government's position that all of the items that were introduced relate don't go to the particular issue that was before the jury, which was self-defense, or are not strong.
I mean, that seems to me quite debatable. Information that he was angry at her before the stabbing, which it seems like from the communications he was, because she's kicking him out of her place and he wants her to let her back. He wants her to let him back in and seems pretty upset about it. That seems, you know, if I am a defense attorney trying a self-defense case, I think that's not helpful to me. You don't want, you know, if your argument is someone was attacking me and I did only what I needed to do to protect myself, evidence that ahead of time you were angry at the person is unhelpful.
That evidence was largely duplicative of.
That's a separate point. To say, to say the evidence on that was overwhelming. So although this evidence went to that issue, which is not what I thought originally were saying, which is that it didn't even go to self-defense. Seems to me it goes to self-defense, whether it made a sufficient marginal contribution to it in light of the strength of the government's other evidence. That's a more debatable topic, but I was having a hard time seeing how it didn't go to self-defense.
Whatsoever. Categorically, I understand your honor's uncomfortability with a categorical statement that it had no bearing whatsoever on that. But what I would say is that not only was the government's other evidence so strong on that point, that even the specific texts and calls that were at issue here were duplicative of other sources of information of those texts and calls themselves. So, so there is a very small bit of information that was not duplicative. And to the extent that had any bearing on the self-defense claim that was being made, it paled in comparison to the vast majority of evidence in the case, which discounted the self-defense claim.
And just to ground ourselves in legal standards, we would be applying Chapman, right? To say that this was.
Yes, harmless beyond a reasonable doubt.
Harmless beyond a reasonable doubt.
Unless the court has any further questions,
We will let you sit down. Thank
we
you.
ask that you affirm the decision below.
Go in the same order.
Hello again, your honors. I'm mindful of the hour. I just want to hit a few sort of housekeeping answers to some of the questions that have arisen thus far, and then briefly speak on the good faith exception and the execution issue. First, the case that I mentioned, Judge McLeese, regarding the retention of extracted cell phone data is Ganeas. It's a Second Circuit case, and it's discussed at page 24 of our brief. Second, there was a question about whether common sense belief that, you know, people tend to have cell phones whether there's case law on that supporting a search to find the physical phone itself. What sprung to mind for me was United States versus Griffith. That's a DC case, 867 F3rd 1265 from 2017. where the court found a lack of probable cause to search a home for a suspect's cell phone and said, we're aware of no case and the government identifies none in which police obtained authorization to search a suspect's home for a cell phone without any particularized information that he owned one. So I think that goes to that point. Regarding severability, I want to be sure to sort of distinguish between severance of valid portions of the warrant versus the question of whether the execution was in such flagrant disregard of warrant limitations as to make it appropriate to suppress all fruits. Those are sort of two separate questions. We think here, following the law of severability that's discussed in Burns, which is this three-part test from Sells, as Judge Easterly noted, it's questionable whether the third part applies, but the first two parts require, say that severability is only applicable if valid portions of the warrant are sufficiently particularized and distinguishable from the invalid portions. Even under just those two prongs of the Sells test, I think this warrant fails because all of the, for two reasons. One, all of the detailed bullet pointed categories, wish list of evidence that the government has in here fall under the overarching header of all records that relate to the offense of murder, including those. And second, because all of those provisions, perhaps with the exception of evidence related to the whereabouts of Mr. Dean on the date of the murder, although even that is vague as to how long before and after the murder, all of those categories are incredibly broad and vague. So I think there is nothing to save. There is no valid portion of the warrant to sever here. Even if there were, even if the good faith exception applied, we think the manner in which it was executed here was so in such flagrant disregard of a clear 1 month time restriction that all of the fruits of the warrant should be suppressed in any event. Turning to the good faith exception briefly. I want to be clear that Burns didn't just distinguish Bass and Bishop as involving a range of relevant evidence. It did say that, but it also said that those cases, quote, even if adopted, so it wasn't agreeing with those cases, but even if adopted, they don't support the government's position in Burns and in the cases since Burns and here that a warrant is sufficiently particular as long as it's restricted to evidence of a particular crime. Rather, Burns said, those cases, Bass and Bishop and their ilk, reflected the rule that we discussed when I was up here before, that warrants of that nature for all evidence of a particular crime will only suffice if a more specific description of the items subject to seizure could not reasonably be provided. So to the extent that there is probable cause in a case like this for a broader range of evidence on the cell phone, that does not absolve the government of the basic requirement to state that the warrant state with specificity what those pieces of evidence are. To the extent that Abney and JFS hold that there was told otherwise, that the prevailing standard before Burns approved of these kind of warrants, they conflict with Burns and Burns should be followed under MAP versus Ryan. I actually think Abney didn't say that. I think JFS, sort of it's like the game of telephone where the message by the time of JFS has gotten to a sort of a statement that seems clearly at odds with Burns, which is that was the prevailing rule, that the particularity standard as it was generally understood before Burns was that cell phone search warrants were sufficiently tailored and particularized where they were limited to searching for and seizing evidence of a specific crime. That's exactly what Burns rejected. So I think Burns controls, and in the good faith analysis, the analysis is just the same here as in Burns. I think Abney and JFS should be limited to their facts. And here, the warrants, the affidavits were just as bare bones as to any probable cause for the vast majority of those 14,000 pages worth of data on the phone. They were just, the warrant to search for, quote, any and all evidence related to the murder was just as sweeping and lacking in particularity as the warrants in Burns. So even assuming there was probable cause for some evidence like communications with the decedent over a 4-month period, it would have been glaringly obvious to any officer executing this warrant that the warrant didn't do the basic thing that warrants are required to do, which is say that, right? it said any and all evidence, and there was clearly not probable cause for that. So for those reasons, we think that the good faith exception cannot save this warrant, just as it couldn't save the warrant in Burns. Briefly regarding execution, I think the process that was challenged below was not, can't be cordoned off to just what the prosecutor did once she had the document, the extraction report in her hands. The process included the translation and the provision of all of that code in human readable text to the prosecutor. I think that objection was adequately preserved. The record reflects that reflects only that the extraction can't be filtered, right? That's what the government insisted on below and insisted on here, is that you can't extract from the cell phone's memory the code for only certain types of evidence or certain dates of evidence. But I think it's clear from the way even if we don't know what Cellebrite can automatically do, it's clear from the way the extraction report is formatted and from the prosecutor's description of how she navigates it, that it is readily divisible by type of evidence and by date. It is not an onerous, we use the term taint team, but this is not an onerous project to go through and pull out the pages that relate to the dates. And that is the sort of bare minimum that we think was reasonably required here, where there was a clear date restriction on the warrant. And I'll just say that the provisions that the government has inserted into this and other warrants in paragraph 35, sort of prospectively blessing their right to look at even cursorily, to look at every piece of evidence, can't trump the Fourth Amendment's requirement that the execution of search warrants be reasonable. It is not reasonable to look even cursorily at evidence that you know is not responsive to the warrant when there is no need to do so. And here there was no need to do so. To sum up, I think the litigation of these cases since Burns, sort of through the good faith exception analysis of pre-Burns warrants, I fear has muddied the waters a little bit on the probable cause and the particularity rules that Burns and Riley and the Fourth Amendment require courts to be vigilant about in issuing cell phone search warrants. And we urge the court in this case, regardless of the harm analysis, to use this opportunity to clear away that confusion by clearly restating Burns's holding that the Fourth Amendment requires that all cell phone search warrants for suspects and non-suspects alike must be strictly limited to the specific data or information for which police have shown probable cause based on particularized facts about the case, and that law enforcement must abide by those limits in executing the warrants, which means not translating and handing to the detective and the line prosecutor every last byte of data on a phone where the warrant is limited to specific dates or categories of data. So if the court has no further questions, I'll ask them to reverse.
Okay, I will take you all to lunch in 3 minutes or less. I have one more point to make about just specific about the procedure used here. In the affidavit, the detective said during a review of the logical extraction, your affiant noted that some call and text data, which were reflected in the call detail records for the seized phone, were missing from the extraction. But in the hearing, the prosecutor actually said and represented to the court that the detective did not look at the extraction report, that only she did. And so this is an extreme problem here. We don't know what procedure she used. And to the extent I was asked about the burden, to the extent that it's the defense burden and a motion to suppress, they carried their burden because the government could not come back and provide the details that even the court was looking for. And then with regard to, going back to the actual warrant, this was just a sloppy affidavit. And all you have to do is look at the affidavit side by side with the Burns affidavit, and it was very similar. The Abney, and then you can look at the Abney affidavit and the JFS affidavit, and they were much more detailed. And so, just as in the Burns rejected the good faith argument, due to the similarity of the affidavits, the good faith argument should be rejected in this case as well. And I'm just going to leave you all with that. And thank you very much. And we respectfully request a reversal. Thank you.
Thank you, counsel, for your arguments and for your stamina. And this case will be submitted and we are now adjourned. Thank you.
All right. This honorable court is now adjourned. Okay.